Yes, item 1. No, why it has come?
Lordship, we have third copy, in fact, officer is here, and the line of here is the third copy, extremely not. There's some confusion, Lordship, they said I have subsequently, tried to call them, they said that they have the copy on the informant, victim, I should have mentioned the name. Lordship is very
Wait, Nagali. Nobody, no?
I make us.
The office will take some time to prepare the paper book. In fact, we'll appoint an amicus curiae on behalf of the victim.
Lakshmi, in fact, it was served yesterday, but the report doesn't disclose as
Date.
date, why not?
So we'll
Yes.
engage appoint a learned amicus curiae in the matter. Both sides are represented. Ms. B. Bhuiyan, Senior Counsel and APP, learned APP for the state, has produced a scanned copy of service report regarding notice served on the respondent number 2. Accordingly, the notice on respondent number 2 is duly served. None appears on call for the respondent number 2. So therefore, the court proposes to appoint she so and so. Can you suggest a name? Can you suggest a name? Amicus curiae list. You will be there?
Yes.
Okay. Mr. J. Kalita, learned amicus, as learned amicus curiae in the matter. Stop. As per the office note dated 16/10/2023, the translation wing requires some more time to prepare the paper book. List after 4 weeks awaiting preparation of paper book. To stop the as and when the paper book is made ready, the same will be same shall be served on the learned counsel for the appellant, learned APP as well as the learned amicus curiae. Next list after 4 weeks. For
suspension of sentence.
I don't think this is a fit case for to suspend the sentence.
There are a lot of contradictions.
Because the as per the narrative, she was purportedly drugged, and then she was assaulted twice.
can be submit. If the lordship may kindly take a date and hear us. That will be highly grateful.
Okay. Because we will need the paper book otherwise also. Uh, just add there. On the prayer made by Mr. A. Bhattacharjee, learned counsel for the appellant, is permitted to renew the prayer for hearing of the interlocutory application on preparation of paper book.
That will take some time.
4 weeks will be required. Because they are working on a project.
I appreciate it.
Huh.
What I'm trying to present this to somebody. The book will be for the final hearing of the appeal. Before that, only the IA.
No, you see, for us, hearing on the appeal as well as the interlocutory application takes the same amount of effort.
I think it won't take much time because once we have advanced an hearing, but on that day, unfortunately, what happened, even the court made up some mind, the other court. What has happened on that day, the notice was not served from the respondent. So there was a prayer made from the prosecution that informant be heard in terms of the amendment that has been in the POXO as well as the observation of our own High Court, that without hearing the informant in a POXO case, perhaps that won't be proper. So now, since an amicus curiae has been appointed, Lordship, so Lordship may kindly fix it. It can be done within 2 weeks. or 3
Then
weeks.
you'll have to type out the what you call the witnesses statement type copy.
It's already given, if I'm not wrong.
But just check up because I have not checked up.
It's given.
Okay. Don't write here in the IA, right? Heard say Bhattacharjee counsel for the applicant, Ms. B. Bhuya, learned senior counsel and learned AVP for the state, and Mr. J. Kalita, learned amicus curiae appointed in the matter, lists the matter for consideration of the IA on, give a date after 10 days.
Look.
In 6.
Yes.
Which was called for earlier from the forensic science level discussion. And later
Yes.
on, they did it 27/9/23.
Okay, the report has not come.
Let's see. Officer is there, let's see.
What we say, they will learned legal aid counsel for the appellant and Ms. B. Bhuya, learned senior counsel and additional BP for the state. As per office note dated 6/11/2023, the report as called for by order dated 27/9/2023 has not been received. So the registry shall issue a fresh reminder to the Court of Learned Special Judge Nagaon to send a report as per requisition wide memo dated 10/10/2023. Next, let this order be brought to the notice of the AOJ criminal appeal. Criminal appeal, na? AOJ criminal appeal section. Based on 1711.
I think More hearing.
Okay, time being.
Then 3, 4, and 5.
3, 4, and 5.
I mean, item number two. I mean, item number two.
3. Okay.
We have proceed.
Yes.
Proceed, this case has been arising out of the process of judgment. The regard by the Rajat Special Judge Baksa Musalpur. That is 1611. However, this the Rajat court below. I think convicted this the accused person. But it is for life and the kind of but the prosecution case is that lordship, and FIR was lodged on 17/4/2011. Lordship have the paper with. Then FIR is at plus 4. Merita FIR lordship.
Yes, please continue.
The FIR that pays full lordship. It was lodged by one promoter Ramsey. I had the honor to state that at about 2 p.m. today, that is on 17/4/11, my son Praveen Ramsiari had gone out of home to Kharwa Sariali by bicycle. Around 3 p.m., I came to know from villagers that around 2:30 p.m., one Ratul Das, son of Lolip Das, Lobiram Das, son of Sobin Das, and Prafulla Das of Komidhar Das, all residents of Kharwa, Bilpa in a group killed my son Praveen Ramsiari as a 33 years by hacking him in his neck and on various part of his body, Lucian night. On receiving this information, I immediately came to Kharwa Sariali and saw that the above mentioned person, after killing my son by hacking him on the neck and on various part of the body with a sharp weapon, left his body at Kharwa Sariali shore. I therefore pray to you and to take necessary actions against the above mentioned persons after carrying out investigation into the matter and computers. On the basis of this FIR lordship, this accused person has been arrested. And after much investigation being completed, the IF has submitted its pursuit. So prior to going into the evidence of this case lordship, I want to call the lordship evidence of the evidence of the search statement.
Yes.
Search is starting from page 119. The relevant portion starts with page 1. Paragraph number 7, which is search for information, nature of offense and circumstances connected with it. concise detail and under what sections of the payment code side. The case in brief is that, that's of the circle. The case in brief is that on 17/4/11, informant promoter Ramshar is son of let's Kiaram Ramshar is a resident of Kharwa village under jurisdiction of this police station. By lodging a written Ezahat to this case, he informed that Rakul Das, son of Robin Das and Prafullo Das, all residents of Kharwa PS Borama, hacked informant's son Robin Ramshar on the neck in the broad daylight and left him in front of Kharwa Karidam. Accordingly, the officer in charge of police station registered the case under section 334 IPC and entrusted me with the charge of investigation. In the course of investigation, the accused persons namely Rakul Das, Raviram Das, Prafullo Das, Sobaru Das, and Bhokeshwar Das were arrested in connection with the case. But no incriminating materials were found against the arrested accused. Sobaru Das, Alkanto Das, and Bhokeshwar Das both are residents of Kharwa PS Borama. Hence, it is fair to the honorable court to discharge from them of both of them from the case. So, I think the case is the procedural case is developed. After lodging the affair, the investigating officer was arrested 5 accused persons. There was including this petitioner, 2 persons were also here. One is Sobaru Das and one Bhokeshwar Das. But subsequently, despite the fact that the persons who have been discharged from this case, that is Sobaru Das and the Bhokeshwar Das, they also himself surrendered before the police station that they are also involved in this case. However, also, despite the fact that they themselves also surrendered, they were also discharged from the case. So that fact that this person were surrendered, that can be ascertained also from the evidence of the investigating officer. That's not it. Before going to fact, I am just drawing the attention of the lordship that there were 5 persons. So, the lordship provide the evidence of the investigating officer. First, may kindly have a look at page 29. The relevant question. Page 29 also. The 3rd paragraph. May I read the paragraph? 3rd paragraph. During investigation, I recorded the statement of witnesses, including the complainant. I arrested the accused person in the case and sent them to jail. Next slide. On the next day, on 19/4/11, the accused Sobaru Das and Bhokeshwar Sharma surrendered before me, and accordingly, I arrested them in connection with the offense. This part will be relevant in subsequent because they themselves surrendered before the police station that they are involved in the case. However, at the time of filing charge lawsuit, the IO has made a prayer to discharge these 2 persons from the charges leveled against the other accused person. So now, after completion of the investigation, the investigating officer has submitted a charge sheet lawsuit and trial was proceeded. Now, before the trial start, this petitioner, Raviram Das, he took a plea that at the time of committing the offense, as alleged by the informant, he was a minor. So, lordship may come to case 7, that commitment order, where it is reflected that the previous petitioner lordship stated that he was juvenile at the time of the commission of the offense. Lordship may kindly the case 7, that commitment order.
That doesn't carry any meaning because the proof of birth was never laid before the court. He did not reduce evidence.
Well, that his plea was rejected. His took the plea that he was a juvenile, but his plea was rejected. Thereafter, also the trial was proceeded, and accordingly, the prosecution has examined as many as 12 witnesses in and 12 cases and 1.
The date of occurrence is
17/4/2011.
Infantry Ocean headmistress of Karwa Anususita Jatiya LP School. She was examined as a witness, and I have just found at page 35 of the paper book, Your Lordship. Wherein she has deposed there, my lord. That Robiram, he studied in our school, he studied up to the fourth standard till the year 2003. Exhibit 1 is a school certificate in the name of
161193
Yes. So it would be
will be major 1693.
3 and 7.
Will be the 17 years in the 15 years or so.
Date of occurrence is 2011.
2011.
I don't know if he was related at the time.
Yeah.
Rashid? Yes, you know. Is 35. Roshi, her name is Numali Boro. Mrs. Numali Boro. She has been arraigned as court witness, your lordship.
Yes, 30.
Page 35. That's fine. Here we go. Jasmine doesn't say anything about the deposition made by the headmistress.
We understand what is happening, but we are unable to have the document on hand. Just give us some time. You see, this page 35 is something which is recorded by judicial magistrate first class. It could not have come to the
Yes.
sessions record.
Yes.
So 164. Or something like
Because that's why she is court witness. It's not in sessions trial, but before the committal proceedings. We are not getting that document.
Statement recorded.
Maybe it took up tea of juvenility and then it was examined.
Lordship, it was recorded on 21.
Well, that is prior to during the committal proceedings. That is committal proceeding.
Yes.
The sessions trial started thereafter.
Order sheet supplementary.
Case diary.
17 को the issue notice করছিল কিন্তু তাতেই দিয়েছিল
It was a
কিন্তু কিন্তু বাংলাদেশ একটু সাইয়ে রিসিপ্ট করেছিল
হুম। Yes, my sister is right. You see, what has happened was in the committal order at page 9, you will find that the committal court had recorded that the entries in the exhibit 1 is based on statement made by mother of the uh, appellant. Correct. Therefore, there is no corresponding entry of date of birth in the school register. And therefore, during committal proceedings, the committal court took into cognizance the school certificate and exhibit 1 and the school register, copy of school register exhibit 2, and rejected the plea of juvenility. So therefore, Mr. Kalita, in the sessions court, you should have given a evidence with regard to the age. So since it is not there, not only the committal court rejected it, but the plea was not taken in the trial. And thirdly, even in this court, when the I was taken up, the plea of juvenility was rejected. So thrice it has been rejected. We can't take up that plea of juvenility now. Okay.
There was nothing mistake in entire court they could have taken a plea that he was a juvenile also. Thereafter nothing.
No evidence was led, and therefore we can't reopen it, because once this court has rejected in the IA, so we have no jurisdiction to review it. So that plea will not stand. Yes, please proceed.
Losses is it's not just an examine witness, clear witnesses also. And one court witnesses also. So if you can just look at page 11, the deposition of PW1, the informant. There was no eyewitness at all. All the evidence and the conviction based on the circumstantial evidence. Motion can just look page 11, the deposition of PW1. PW1. You see, all the accused persons are my co-villagers. I know accused Profulo Das by name and face, and I know the father of other two accused persons. This is Govinda Ramchari was my son. The incident occurred 2 years ago around 1:30 p.m. There are one Shiva temple and one Kali temple at Kharwa Sok at our village. I found Govinda Ramchari dead with cut injury on his neck. He was found lying dead at Kharwa Sarili in front of said temples. The accused surrendered before the police station and they told the police that they have committed the murder of Govinda Ramchari. While the accused person surrendered before the police at police station, their hands were bloodstains. Police told me that the accused surrendered before the police station and confessed to have committed murder of Govinda Ramchari. This was my only son. I do not remember now whether I lost any azahar. The police recorded my statement. Postmortem over the dead body was performed by the doctor and thereafter handed over to us. In cross for all accused persons. I have not seen the persons who have committed murder of Jesus. I do not remember now whether I lost any azahar before the police. It is not a fact that the police did not tell me that the accused surrendered before the police station and confessed to have committed murder of Govinda Ramchari. My son Govinda Ramchari was surrendered NDFD. It is not a fact that the accused persons did not kill my son Govinda Ramchari. It is not a fact that I have deposed falsely in the court. At the time of occurrence, I have gone to attend Bihu invitation. I do not know if my son had any enmity with the other organization. I used to maintain cordial relation with the parents of accused person as well as the accused. Also from this evidence, nothing can be ascertained that this person has been involved in the crime, because he himself even doesn't know that whether he lost any FIR or not. In chief as well as in the cross-examination, he has admitted that he doesn't know whether he lost any FIR. So, let's may come to the next page 13. Is the PW2. He is Robin Bosumatari. I know informant Pramodhar Ramchari and also I know his son, this is Govinda Ramchari. I know accused Profulo Das. I do not know other two accused persons present the dock. The occurrence took place at around 2 years ago. At the time of occurrence, I was at Borama Market and returning home at 8 p.m. I came to know that from my wife that Govinda Ramchari was killed. So from this evidence also, nothing can be ascertained. Next is the PW3. Is a Bonomali Das. I know complainant Pramodhar Ramchari and also I know all the accused persons. I know accused persons are present. All accused persons are present in the dock today. I knew this is Govinda Ramchari. The occurrence took place around 2 years ago on 4th in the month of Boisak. The occurrence took place at Kharwa Sok near Kali Mandir and Shiva Mandir. My grocery shop is situated nearby the place of occurrence. It is at the time of occurrence I went to the house to attend an invitation in another village. In the evening, I returned therefrom. In the meantime, police came to the place of occurrence. I came to know from the police that somebody killed Govinda. This person also lost it, either lost it by hair or lost it by sin. He has not implicated this accused person in the case. Now, PW4. PW4 is also a police personnel, Govinda Vaishya. On 17/4/11, I was at sentry duty at Borama PS. At about 4 p.m., the accused person present in the dock today came to the police station with 2 bicycles. They confessed before the OC Borama PS that they have killed one person of NDFD by means of a knife and they have produced the said knife before the OC Borama PS. SI Provin Bavarali seized the said knife at PS in our presence. Exhibit 1 is the scissor list. Exhibit 1-1 is my signature there. The length of knife is approximately 9 inches with a plastic handle. The said knife was bloodstained.
material exhibit 1 is the said knife. The accused person disclosed before the OC in our presence that they killed Govinda Ramsiari. In cross lawsuit, I recorded my statement. It is not a fact that I did not mention the name of Govinda Ramsiari before the police, since disease to have killed by the accused persons. It is a fact that I did not state before the police about the length of the knife. It is not a fact that I did not state to the police that the knife was having plastic handle. This line is lawsuit relevant. At the time of seizure, other than police personnel, none was present. This line will be lawsuit relevant subsequently. So other than lawsuit police person, none was present at the time of lawsuit seizing that state material exhibit. It is not a fact that I have deposed falsely. It is not a fact that nothing was seized from the possession of the accused person. So lawsuit, this person says that at the time of seizing.
No, these discrepancies are not very fatal. These are not contradictions. They are mere discrepancy. Hmm. Because you see, the sequence is that there was a murder.
Yes.
The neck was slit off. There is evidence to show that earlier the deceased assaulted this Ravi Ram Das. Ravi Ram Das hit him back and thereafter brought out a knife and slit his throat. After that, with the hands and clothes stained with blood, they went into the police station and surrendered. In police station, there are witnesses who say that number PW1, PW4, PW7, PW9, and 12, 11 and 12. They say that you confessed and you produced the knife before the police, and the police seized it. Then there's a confessional statement. There's a denial of confessional statement in the 313 statement. But PW11, who's the SDGM, who was examined as witness, was not cross-examined on that point. There's only 3-line cross-examination. So there's nothing. So therefore, you see, unless you can demonstrate that the evidence is the creditworthy of the witnesses or the evidence is not there, minor discrepancies here and there will not dilute the conviction.
The thing is that lawsuit, the case of the prosecution is that this person was surrendered before the police station lawsuit, and accordingly the materials exhibited was seized from the day. The thing is that the one person has only one person, that is and not for that person. He has confessed that before the magistrate that he was involved in that crime. Now question is that logic, whether lawsuit of confessional statement made by co-accused can be fully supported and convicted the other accused also. In a series of considering the event of series of events also.
If it is inculpatory, why not?
Lordship, there might be lordship enmity also. Lordship cannot presume that he all are involved in that at the time of offense also. That cannot
No.
be presumed.
You see, assuming that there is no in this case, there was it's a fact that there is no eyewitness to the crime. Correct. Therefore, circumstantial evidence.
Yes.
The fact that the knife was produced by you before the police itself becomes a incriminating circumstances. And number two, if you come to section 8 of the Evidence Act, it becomes the what you call the conduct of the post-crime conduct of the appellant, that itself becomes a circumstances.
Yes, but only thing is that whether the prosecution has followed all the procedure to be complied with regarding this procedure. When a person was surrendered before police station, what is the next role also? Whether they have complied with all this procedure. First thing. The second thing is that whether trial court has complied with all the procedure also to convict some person on the basis of confessional statement of co-accused. That has to be looked into also, because the trial court has
Is there the magistrate said that they gave 8 hours time to the accused person to reflect. That is what is.
That is clear also. On reflection is that. My one single point of view and last come here. Thing is that the confessional statement on the basis of which this person has been convicted, that has to be put into as a question during the time of examination of the accused person at the section.
That is there. That is there.
That is not there regarding this person.
No, it's there.
No, Lord,
Is there?
Lord.
Is there.
Yes. Yes, Lord, it's said. Page 47, not to
No, come to page 50. That question is at page 50, 50.
yes. Question number 11 also.
Yes.
PW 11 Srimati Nirmali Talukdar, the then SDGM as Nalbari reports that on 18/4/11 at 3 p.m. the IO produced you and two other co-accused in her court for recording confessional statement. Thereafter, she explained regarding the consequence of making confessional statement and that you were bound to confess, and if do so, the same would be recorded and would be used as evidence in the trial. What have you got to say, reply? I was taken to get my confession recorded, but I did not make any confession. Now the question is that, this was only the statement there. This question on this lordship disclosed that they were brought to the police station or magistrate lordship to record their statement. Now the question is that my submission is that, regarding the confession made by the co-accused, that question has not been put this person, lordship.
Yes,
So
yes,
how
it is
the
there.
question-
Additional question. What do you call? There's an additional question put. I won't be able to locate it immediately, but it is there. 52. 52. Yes. Additional question.
I didn't see this line.
Mm-hmm.
Co-accused Datodas made confessional statement that on 2nd for this is Govinda Ramshari assaulted you and you and him, for which the Datodas gave a close hand blow on his person, and you also gave him a close hand blow. Thereafter, you cut on his neck with a knife bringing from somewhere, and at the time he was also giving close hand blow on Govinda. Then you, along with Ratul Das and Prafulla Das, going to Burma police station with a bicycle and surrendered there. What have you got to reply? The above confessional statement of the accused Ratul Das is false, and I was not present at the place of occurrence because I was at work at the time of the event. So, Lordship, this is the denial by this person that she was present.
No, but there's no, no. There's no defense witness examined because the question was put
Not necessary in criminal case, Lordship.
for plea of alibi.
Plea of alibi, Lordship, I take the plea of alibi, but it is not my duty to prove that I was not present. I have to prove that.
No.
Lordship.
No. Then you are horribly wrong.
No, Lordship. This is not. This is the settled law in criminal.
Once you see, now you see, let me see a strange example. I say that on that day, when the occurrence took place, I was in the moon. I am not Neil Armstrong, but I still say that I was in the moon. Correct. Now, if I take that plea, can it be acceptable to a logical mind that it will be the prosecution who will have to prove it?
Definitely no, Lordship.
You see, prosecution has proved that his presence because of the fact that there was a person who has died. Corpus delicti is there. Number two, the surrender before the police is there. The knife, which was the weapon of assault, was there. Confessional statement is there. So therefore, circumstances otherwise complete. Now you may take a plea number one that the knife was not sent for forensic examination, but that is not fatal because of the fact that when it can be shown from the postmortem report that the nature of crime is with a sharp weapon.
He can assert only FSL Lordship examining after postmortem report, only Lordship ascertained that it was killed by some sharp weapon or blunt weapon, whatever it is. But Lordship, the FSL report, without examining the Lordship serology test of this weapon used in the crime, Lordship, they cannot say that this person was killed by this weapon because only one knife.
That nobody can say.
Yes, only one
That-
knife was police report.
You see, postmortem report, they are not experts in that detection of crime. No postmortem, no doctor will say that he was killed with this weapon, particular weapon. If you are suggesting that, if you have some authority, you will be enlightened, because they will only say you see, they are giving an opinion on death. They will say that the throat was slit with a sharp weapon, and the death occurred due to bleeding, hemorrhage, and asphyxia resulting from the or whatever language they want to use, they will say that it is because of that. So therefore, that makes that is the medical evidence. Medical evidence is not connected with the weapon, which is the weapon of assault. So it's a sharp weapon. Sharp weapon was produced by this accused before the police. The circumstance is complete. If you want to say otherwise, we'll need some authority on that point.
It was the only statement of the person, the second person. I never confessed before that I have killed that person and this was the weapon we used. We have never, neither this one lordship nor under section 313 also we have stated that we killed that person by lordship knife. That was the statement of the person who only confessed before the exam lordship, not of us. So that lordship, without lordship establishing that this weapon was used at the time of lordship occurrence, that cannot be lordship the basis of conviction of the second person. The prosecution also clearly established that yes, they were lordship signed up before the police station and accordingly following due procedure of law lordship, these four documents were seized and the materials is like knife were seized, and after lordship following due procedure like forensic laboratory report like was shared with the test, it was ascertained that this weapon was used and the blood stain lordship which was in the knife, it was the blood of the accused person that this person lordship. That has to be ascertained by the prosecution. It is not of my duty lordship, the accused lordship may not produce adduce lordship any evidence. That cannot be taken by the prosecution that they did not lordship adduce any defense evidence. In the criminal case, the prosecution clearly established that yes, it was the lordship knife which was used at the time of lordship occurrence, and this report clearly indicates that the blood lordship which was in the blood stain in the knife is the lordship blood of the deceased person. That has to be ascertained by the prosecution. That was not from done lordship by the prosecution. And the person lordship who has been produced as a witness of seizure witness, lordship may kindly read the evidence of seizure witness. First, number 4 is the seizure witness lordship. I have already gone to the code of evidence of 4, when he has stated that except police person, none was present in PW4. Then lordship may come to page 5. All are contradictory. Lordship may come to page 5. To page 17, lordship, PW5.
Page 17.
Lordship. Page 17 lordship. This was evidence of Constable Talukdar. He was also a seizure witness. The incident took place in the year 2011. At the material period, I had a pawn shop and stationery shop near Burma police station. And I came to know that 3 boys in Govinda Ramsey of NDFP. I came to police station to see that those 3 boys. I saw those 3 boys in the police premises and those 3 persons are in the dock today. Police seized a knife having a plastic handle from the possession of accused person and seized the same. Exhibit 1 is the seizure list and Exhibit 2 is my signature thereof. Metal Exhibit 1 is the seized knife in cross lordship. At the time of seizure, I was present at PS. My shop is situated at a distance about 100 meters from the PS. It is not a fact that I did not state to the police that the accused person disclosed before the OC in our presence that they killed Govinda Ramsey. The next time is at the time of seizure, other than police personnel, I was present at the PS. Wherein was it PW other than police personnel, I was present. And the next time was it. I came to know the name of the accused Prafullo after seizure. The knife which was seized by the police was alike that of Metal Exhibit 1. He has not said that this was the knife it was seized. It was alike like that. Was the same knife, maybe 100%. You said that it was alike that knife which was seized. He has not said that this was the knife seized at the time when this person signed it. Next line also. I put my signature on the seizure list after the same was prepared by police. Police read over the contents of the seizure list prior to obtaining signature here. I do not use to visit police station. If any person come to my shop for writing Azahar, I did so. Lordship, he was a petition writer. He was neither a lordship independent nor a lordship this police personnel. He was like a sans witness lordship, because he only used to visit police station to write Azahar. So lordship, he was a petition writer only. So that his evidence lordship cannot be lordship taken to consideration for conviction lordship, because he himself said that I used to write Azahar when someone approached me. So lordship, he was a petition writer. He was not an independent witness lordship. But that as far as the seizure witness lordship, as per CRPC, the person who lordship sees the documents, he has to lordship took signature of independent witness. So this person cannot be said as an independent witness. And one is the police person. That also lordship is a very shrouded lordship that cannot be taken into consideration. Lordship is PW4. Next is PW6 lordship. His statement is called PW6 is Arup Kumar Burma. He also give a contradict with the cross-part lordship. Time of seizure is around 2:30 p.m. I do not know the name of the accused person. Who told the accused person from whom the police seized the knife was present before the court in the dock today. At the time of seizure, I along with another police person were present at PS. No other person was present. So lordship, his statement also contradictory with the statement made by the lordship PW5. PW5 says that lordship, along with the police person, he was present. And this person, PW6 and 4, stating that lordship, no other person was present at the time of lordship seizing. And lordship, it was the duty of the police lordship before seizing all those materials, they could have called to independent witnesses from nearby stop and all lordship to complete at least the formalities. They have done nothing. Merely lordship, the person who himself seized the document, likely he put his signature like a lordship, his fellow person, lordship, the police person. So there was no independent person lordship to establish the case that this person surrendered before the police station. Number 4, lordship may come to case 21. Case 21, Pratik Basumukati. I know the informant Pramodar Ramsiari. Also, I know this is Govinda Ramsiari, and also I know accused persons who are present in the club. The incident occurred around 3 years ago, around 9:10 a.m. It means something different. The father of the deceased come to our home and informed me that his son was killed. He informed that the deceased was killed at Kharwa Shop. The shop is a junction of 4 roads. All these roads are village roads. I rushed to the said shop and found the deceased lying dead there. I noticed cut marks on the neck and leg of the deceased. During my presence at the place of occurrence, some people came from Barama Bazar and they informed me that the accused Robiram Das, Ratul Das, and Popolo Das surrendered before the police station, Barama police station, after killing the deceased. Those accused persons are present before the court today. This was my nephew. During my presence at police place of occurrence, police came there and held inquest over the dead body of the deceased Govinda Ramsiari. Exhibit 2 is the inquest report. Exhibit 2.1 is my signature. I know Nomali Boro, wife of Sri Rajani Mohan Boro of village Kharwa, said Nomali Boro is a teacher and he is alive. Because I cannot remember now the week of the day of occurrence. Place of occurrence is situated at a distance of less than half kilometers from my house. It is the fact that I did not state to the police that I noticed cut marks on the neck and leg of the deceased. Police asked my name only. But did not record my statement. So lordship, this evidence, if her statement was not recorded during the lordship investigation, her statement cannot be lordship used to convict a person. This only lordship the police put her signature only. Nothing was asked lordship or nothing was recorded before. So lordship, this evidence cannot be lordship the basis of conviction. Now lordship may come to the evidence of Nirmali Talukdar. PW lordship at case 26. Nothing about my brother. Lordship may come to case 28. Case 28 lordship with the discussion of investigating immigration lordship. Robin Moral. On 17/4/11, I was posted at Barama PS, and on that day at around 3 p.m., 3 boys came to the police station with a blood-stained knife and told that they had murdered a person named Govinda Ramsiari at Kharwa Shop. They also produced a spectacle before me. Accordingly, I lost GD&T. Not if this person will be relevant subsequently. I lost the GD&T number 398. Date 17/4/11. I seized the blood-stained knife in presence of 2 witnesses from the accused. witnesses from the accused person. Exhibit 1 is the scissor list. Exhibit 1 4 is my signature. Exhibit 1 5 is the signature of accused Rabul Das. 1 6 is the signature of accused Gokul Das, and 1 7 is the signature of accused Robiram Das taken by me. I reported the incident to the SP of district as well as CI. In absence of the OC of police station, the SP of the district directed me to investigate the case. Accordingly, I visited the place of occurrence. I saw a huge gathering of public with exciting mood and the place of occurrence. I saw the dead body of Govinda Ramsari lying on the road. I called the executive magistrate to the place of occurrence for inquest of the body. Accordingly, executive magistrate, namely Sanjit Kumar Awari, came and conducted the inquest on the dead body by exhibit 2. Exhibit 2 4 is my signature. Exhibit 2 5 is the signature of Sanjit Kumar Awari, executive magistrate, which I know. I prepared the sketch map of the place of occurrence by exhibit 6. Exhibit 6 1 is my signature. I brought the dead body to the police station and onwards transmission to hospital for postmortem examination. On the same day at 8 p.m., Padmeshwar Ramsari, the father of the victim, appeared at the police station and lodged a written exhibit by exhibit 7. Accordingly, the Boroma Place case number 72 was registered and endorsed me to investigate the case by OC. Exhibit 1 is the signature of the then OC of Boroma Place, Chief Sarat Das, which I know. During the investigation, I recorded the statement of witnesses, including the complainant. I arrested the accused person in the case and sent them to jail. On the next day, and on 19/4/11, the accused Sabaru Das, Lokeshwar Sharma surrendered before me, and accordingly, I arrested them in connection with the case. So, this person themselves surrendered. But why the prosecution was discharged them from this case? Nothing was there in the charge also. The person was who himself admitted that yes, I killed the person and I surrendered. That person was discharged from this case. This is not a complete suspicious case also. And prosecution has miserably failed to establish the case. Because why they have discharged this person, not even in charge and this person mentioned. Why this person was discharged from it? Who does he himself surrendered to the police station? And that this Sabaru Das logic, I will come later. Sabaru Das is a logic person whose shop is in front of the place of occurrence. Whose shop is in front of place of logic. If logic go by the case map, logic will find this person Sabaru Das, his shop is in front of the place of occurrence. And he himself surrendered logic, but he was discharged from the case. Without any assigning any reason logic, why he is being discharged.
No, that you see, we are not called upon to answer that.
No, that
So
is.
please understand. Number one, somebody has been discharged.
Yes.
Nobody approached the court for what you call revoking the order of discharge and to not that. But you see, something you say we'll have to deal with it. That's why I'm saying.
That
Well,
is
it's not that everything we hear will not reflect in the order. No, but you see, no. Second thing is that in the cross-examination of the IO, these questions were never put.
Even if the methods are there in that case record, even if the person was a good cross-examine this IO, perhaps he skip this point.
No. You see, because you see, there are several legal propositions. Number one, a person who has surrendered has been discharged. Whether that will become a ground for to discharge the second person who is also a co-accused, that is not there. So therefore, that circumstances is of no use of this court. Because if you can otherwise, you see, you did not lead an evidence. Otherwise, you could have thrown the burden on the co-accused, but that was not done.
I will come later on. There is no burden at all the accused person in criminal prosecution.
No.
It was the duty of prosecution. They have to establish everything also.
No, you're not getting the point. You're not getting the point. You see, you are now saying that since one the co-accused was discharged, your question is that why he was discharged and why I was convicted. That is your question.
Right.
I'm only responding to that. It was your question, therefore we are responding. Number one, in a criminal, you'll excuse me if I go wrong, because I am basically a what you call product of CPC. So when I am dealing with CRPC or IPC, you'll excuse me if I go wrong. Now you see, number one, the principle is that in the criminal trial, it is always the burden of the prosecution to prove who has done what. And if that four circumstances I have told you in the first, there are four circumstances which lead to a circumstantial evidence against you of having murdered the person by slitting his throat and then surrendering before the police with the knife. The evidence is to the effect that first the deceased attacked you with a blow. Then you retaliated with a blow, and thereafter you produced this knife from somewhere, and then from where you produced, nobody saw, but you produced that knife and you slit the throat. Correct. So therefore, the failure of the prosecution is basically three. Number one, the knife was not sent for serological examination. The bloodstained clothes of the accused was not sent for the serological examination. And third, which you are pointing it out, is that the witnesses did not describe the knife properly. These are the three circumstances you are saying. Number one, we'll go from backwards. Number one, the identity of the knife was never in dispute because of the fact that when you cross-examine this IO, PW11, I think, 11 or 12, he's the IO. 12. So in his cross-examination, you could not demolish that this was not the what you call knife which was produced by you. Second, the misdescription of the knife, although there is no misdescription, you are the defense is trying to point out that none of the witnesses said that the knife had a plastic handle. You see, does this question ring a bell to you? You can understand the implication of this question, that you did not tell the IO that the knife had a plastic handle. Does it mean does this question mean anything to you? No, it's not triggered anything to you. You see, when you say that the knife had a plastic handle, that means knife is an admitted fact.
I have never said that.
No, not that, but that is a cross-examination.
Cross-examination.
So you see that identity of the knife is proved by that question.
It's not true cross-examination because the person.
I don't know, but I have read somewhere.
Themselves said that this knife was alike that knife which was seized.
No, alike means, you see, let us say this is a pen with me. Okay, this pen may be available with hundreds of people. Now, if I say this is the one, I must have some proof of what is this, because I will not be able to tell you when you ask me a question in cross-examination that was the refill, how much refill was what you call exhausted and how much ink was left. If you ask me that question, I will not be able to say that.
But one thing can be a certain logic. If logic show two different pen, like this was used in the year 2011.
You will not remember. You see, this is a pencil. I can't say. It's in my hand. I can't say what brand it is. You can't say. You know, there are many theories of witnesses. If you read the theory of witnesses, you will come to know. Number one, let us say there was an accident just in front of the High Court gate. There was an accident. Somebody came in a scooter, slipped and fell down, and he suffered some injury. Correct. There are hundreds of lawyers who will be there in this peak time of 10:15, coming in, going out. Now, if I ask you a question, let us say that you are one of the witnesses and I am cross-examining you. My question to you would be, Mr. Kalita, you were in the High Court gate. Who was give me the description of the sentry who was standing there when you came in. High Court gate will have sentries. Two sides, there will be policemen, there will be two on the road managing the traffic at 10:15. Let us say I ask you this question. Can you describe the sentry who was standing on the gate? Your answer will be no. No, I'll tell you why. Because you see, if you ask today in this courtroom, if I ask you that, Mr. Kalita, you are here in this courtroom number 7, please tell me how many lawyers were sitting behind you. You have to say, I don't know. You see, these questions are merely certain discrepancies These are not contradictions which will demolish the case. Merely because you can't give a head count of the people or lawyers who are present here will not make it a contradiction.
One thing, Lordship, if Lordship asks me, Mr. Kota, when you were inside the courtroom, did you talk with some person? If I, Lordship, discuss with somebody.
No, that is not an
then
issue.
I
You
will
see, in a
say that
crime, in a crime, this
Not
question will never come. Speaking to somebody is not a crime, and therefore that evidence is useless so far as my limited understanding is concerned.
yes, I am also trying to get a contradiction part. Yes. whether-
No, contradiction will not come from asking two questions to two witnesses. It will come only when you ask the question to the IO.
Lordship, and it will be, Lordship, it has to be examined as understood.
Because I will say that whether when you're investigating, you see,
Yeah, I have part.
no, you see, I say that I was present in the court. This incident happened when I was in court. Correct. But because of my office, I am stationed in this chair, or in the chamber, I am stationed in one chair. So these are my what you call area of operation. So if something has happened in the corridor, I would not know it. So merely because I was there in court does not mean that I have seen it. Merely because I was there in court does not mean the others were not there. Place of the knife being surrendered is inside the police station. So if somebody says that I was in the police station, will not make it negative. Because the police will say, we will go, look out from the window or from the gate and say that, okay, you are there, come in. Sign this as a witness. I am just giving a hypothetical situation. So therefore, a mere presence in this case, in the premises of the police station and present at the table of the seizure are two different things.
Depending on. So this knife was seized at police station also. And I have seen the knife. I have seen and thereby I put the signature. Yes, this is.
You see, unless you see, those argument doesn't take you anywhere. The reason being, number one, the police did not ask the witness to sign on the seized article. Therefore, nobody will be able to say that this is the one which was seized.
If that's the knife and it's any ordinary knife, there might be different. Even after 2 years, the plastic knife, that might be used in all
You would not remember. You would not remember. Just if I ask you what you call about the knife which is there in your house 6 months ago, you will not be able to say that what nature of knife is available in your own home which you use daily for cutting vegetables. I'll not be able to identify. I use it daily, but I won't be able to identify today morning which knife I used for the purpose of cutting the vegetables to have my own soup.
Thing is that the person will be convicted. That is why the of seriousness has to be dropped. Because if ordinary use and used for conviction a person, convicting a person, is a different issue. So that's coming to the letter part of IO. Page number 29.
Yes, I'm there.
During investigation, I recorded the statement of witnesses, including the complainant. I arrested the accused person in the case and sent them to jail. On next day, and on 19/4/11, the accused Sabarudas Mr. Sharma cited before me, and accordingly I arrested them in connection with the occurrence. I paid the court to record the confessional statement of accused Robiram Das, Rakul Das, Prafulla Das, Sabarudas. So, Lordship, see the line. The Sabarudas also Lordship stated that he wanted to confess, and accordingly he was produced. My question is not to the Lordship. My question is to the defense. They have to prove the why this person's Lordship will not examine or not Lordship bring home under this section. Because I'm not, although I'm arguing before Lordship, I'm not putting any question, but that has to be replied by the prosecution why they were Lordship dismissed from the state. Because the person Lordship who himself also admitted that yes, I want to confess my guilt, Lordship. And he was brought to the Lordship magistrate. Subsequently, on her ground, that link has to be Lordship complete. They have to show the completeness of the link. Accordingly, the accused Rakul Das made his confessional statement in the court. Exhibit 4 is the confessional statement of the accused Rakul Das. Exhibit 415 to 420 are the signature of accused Rakul Das, which I know. Other accused person, namely Robiram Das, Prafulla Das, as Sabarudas declined to record their confessional statement. So, I sent the requisition to the doctor during postmortem examination to collect the blood sample of victim, but it was not done. Lordship, I sent the requisition to doctor during the postmortem examination to collect the blood sample of the victim, but it was not done. Exhibit 10 is the requisition memo. Exhibit 10 was my signature. I sent the dead body of the victim, fight exhibit 9, the dead body salad. 9-1 is my signature. I collected postmortem examination report of the victim and copy of confessional statement of accused Rakesh. I completed the investigation of the case and handed over the case to the OC concerned. On 23/8/11, the additional SP of district supervised the case diary and directed to submit the charge sheet. Thereafter, having found materials, I filed charge sheet against the accused Robiram Das, Ratul Das, and Prafullo Das, but I did not find sufficient material against accused Sabaro Das and Rupesar Sharma. Exhibit 8 is a charge sheet. Exhibit 8-1 is my signature. Now, cross-file also. The case 31. At the time of investigation of the case, I was SI of police in probation. On the basis of the GGNT number 398 dated 17/4/11, I proceeded to the place of occurrence for preliminary investigation. Without endorsement, I proceeded to place of occurrence on the basis of GGNT. Formal FIR was lodged at the police station at 8 p.m. on 17/4/11. On the basis of GGNT, I proceeded to the place of occurrence. Recorded the statement of witnesses, including seizure witnesses, under section 161 CRPC, and also due the sketch map of the place of occurrence. Immediately after receiving formal Ezaher, I did not visit the place of occurrence on the relevant night, as I had already visited on the basis of the aforesaid GGNT. After receiving the formal Ezaher, the officer in charge of Boroma Police Station registered the case and endorsed the same to me for investigation. I have not submitted any document showing that the SP authorized me to investigate the case due to absence of the officer in charge of Boroma PS at that relevant time. He has stated that a written order is not required, and as such, the order is oral order is generally given orally. I have not submitted separately the extract copy of GDNT number 398, that is 17/4/11 of Boroma PS. I did not send a knife which the accused person deposited before Boroma Police Station for FSL for serology test to ascertain whether there was human blood stain there or not. I did not collect the fingerprint of the accused person. I did not seize any bicycle from the accused person. I also did not seize any wearing apparels of the disease. In the dead body salam, there is no mention of GDNT or PS number, and also the exact time of sending the dead body to the hospital for postmortem examination. PW4 did not state me specifically about the length of the seized knife and color of its handle. PW5 Ghanshyam Talukdar may be the scribe of the exhibit 4. He is the Roshi writer. It is not a fact that I sent the accused Ratul Das under threat to the court for recording his confessional statement. It is not a fact that I did not properly investigate the case and such it was not legally submitted. It is not a fact that at the relevant time of occurrence, as I was SI probationary, as such I did not have any power to investigate the case. So, lawsuit, from the evidence of cross-examination of this person, he has done nothing exactly, honestly speaking, because he has neither sent the knife for official examination, nor he lawsuit took any fingerprint of the accused person that the knife they were holding lawsuit at police station, nor lawsuit the blood-stained clothes of the accused person as well as the disease oil lawsuit also. So lawsuit only on the mere statement of co-accused that yes, we killed the person, that cannot be the basis of lawsuit convicting a person for imprisonment for life. The prosecution has to clearly establish lawsuit that yes, this is the case and this was the procedure we have lawsuit duly followed. Nothing was done and only merely lawsuit charges was submitted and no explanation was given why the person who himself stating that yes, I killed the person, yes, I want to confess before the trial, why he was discharged. They have to lawsuit establish that yes, why this person was discharged from the charges of this case, who himself was surrendered and wanted to confess before the court also. So from the evidence of prosecution lawsuit, it can only be said that yes, there is no case of prosecution. There is no evidence, no formal evidence is there. Only these are formal evidence on the lawsuit. Now, next one is the deposition of CW1, court to witness number 1 lawsuit. He also lawsuit giving a different view regarding the GDNT and all. page 33. Today, I have appeared before the court along with the original GD entry register volume 4 with effect from 27/3/11 to 27/4/11 of Boroma Police Station as directed by this court. The register which I have produced before this court today contains Fira's entry relating to Fira's date and time within the aforesaid specific period. The register also contains GD entry number 398 dated 17/4/11, which was in English translation read as follows. At 3 p.m., I see Ratul Das, Lohit Das, Robiram Das, son of Sobin Das, and Prafullo Das, son of Fonidhar Das. All of Fides Kharuajan, P.S. Boroma, appeared in person with one knife approximate length 10 inches and verbally informed S.I. Sarat Das that they had killed one Govinda Ramseri at Kharuajan Shop by cutting his neck. The bloodstains were also noticed on the garments of the accused persons and the knife. Accordingly, the accused persons being suspected of committing murder were kept under the vigilance and guards in the Thana premises. The knife was seized from their possession. S.I. Sarat Das accompanied the staff was prepared for proceeding to the place of occurrence for investigation. So here, this from the extract of the GDNT, it can be ascertained that this person was the IO, who is in his evidence saying that he was in GDNT. Accordingly, he proceeded for that was completely false. Yes, falsely deposed before the court because this court witness saying that once Sarat Das was there, he made the GDNT lordship. Accordingly, he prepared for proceeding for investigation. Two persons of this prosecution witness number 12 and the court witness number 1 are quite different lordship. So lordship, on the basis of this contradictory statement, who are lordship the court witness, not an ordinary witness lordship, not an interstate witness, not a sound witness. They are the court witness lordship. On the basis of statement, they have deposed. From the extract of GDNT, it can be clearly ascertained lordship that GDNT at the time of GDNT, this person, the PW3 was not present. PW12 was not present. Lordship. No, lordship, this person saying PW court witness number 11, one saying that lordship, this video was made by one Sarat Das. Next, lordship, page 34, the cross point. S.I. Sarat Das made the said GDNTs. Within 12, lordship, himself saying that yes, he made the GDNT, he was the GDNT, he proceeded for investigation.
Not enough to puncture a hole in the evidence. You know why? Come to the first line of this page 33. This is a GD entry register volume 4 with effect from 27/3/2011 to 27/4/2011. The date of occurrence is 17/4/11. So 17/4/11, he says that three persons went there. Correct. Now you are saying that the PW11, PW12, he is Praveen Bharali. Correct. Second name is Praveen Bharali. He is there. So these three people have gone there. So what is wrong in this?
Praveen Bharali is saying that he made a GDNT according to he proceeded. And for the GDNT extract, we can be saying that the person, the Sarat Das was there, he only was the GDNT and he proceeded for investigation.
Yes.
So the different things. The statement of PW.
I am not being able to follow you.
PW12 with the IO in his sheet, he has stated that he was the GDNT. Accordingly, he proceeded for investigation on the basis of the GDNT. Now the court witness saying from the extent of the GDNT that yes, GDNT was made by Sarat Das and Sarat Das proceeded for investigation. We can go for investigation.
What is the GDNT?
We are not still following you. The GD entry was made by the PW12.
As per his statement. As per his statement. As per his evidence.
Correct. So he made that statement and he proceeded for investigation.
But that court witness number 1. who on the basis of the extract of the GDMT, keeping in hand the GDMT, he saying that GDMT was made by Sarat Das and accordingly, Sarat Das proceeded for investigation.
No, no, when does it say Sarat Das? Page 34,
Read it again also. Page 33,
page 33, yes.
the second paragraph. The register which I have produced before this court today contains figures entry relating to figures, dates and time within the associate period, specific periods. The register also contains GDMT number 398 dated so and so, which in English translation read as follows. At 3 p.m. 1 Robiram Das son of Lohit Das, 2 Ratul Das son of Lohit Das, 2 Robiram Das son of Sobin Das, 3 Prafulla Das son of Fonidhar Das. All the village Kharwazar, yes, Barama, appeared in person with one night, approximate 10 days, and verbally informed the SI Sarat Das that they have killed Govinda Ramsiari at Kharab so by cutting his neck. Blast stains were also noticed on the garments of the accused person and knife. According to the accused person being suspected of committing murder, were kept under vigilance and guard in the Thana premises. The knife was seized from the possession of from there. SI Sarat Das, accompanied by staff, was prepared for proceeding to the police place of occurrence for investigation. At 3:20 p.m., GDMT number 399, dated 17/4/11, contains the following in English that SI Sarat Das, SI Govinda, CI Chalbari, one section of FPBN and one section of AISF proceeding to the place of occurrence. Exhibit 10 proven original is the first page of the say GDMT brought by me today. Exhibit Y proven original is the GDMT number 398 dated 17/4/so. Exhibit Z proven original is the GDMT number 399 dated so. In cross, SI Sarat Das made the said GDMT. So in PWS 12, he is saying that he made the plausible GDMT and he proceeded. And court is saying no, this GDMT was made by Sarat Das. Subsequently, by GDMT number 399, they proceeded for investigation. After half an hour or 20 minutes, they proceeded. So and Sarat Das was not examined lordship as prosecution officer. Who are the lordship of vital witnesses? Because his present everything was done. He was not prosecuted. He was not examined in court. And in his presence, the surrender was also made. Surrender, everything was done in his presence, but he was not examined.
Mhm.
Not sure, but we take it where it is done.
Hmm.
See, reading that. He recorded his video.
Mhm.
So, this was awesome.
Hmm.
He recorded his video.
Really?
You know, it's one answer. Is it so? Oh, you can tell everyone. His story, because of this one, his story.
Come to page 3.
Page 3, Lordship.
Page 3, 13. SIP Praveen Bharali PAC to investigate the case and to take up the
It
investigation.
was after registering the case, not before lordship on the basis of GDNT. It was after lordship registering the case, lodging by the, after lodging the affair.
This, you see, this hardly matters.
No, lordship thing is that he deposed that before lordship lodging affair on the basis of GDNT, he proceeded for investigation. And this lordship, he was endorsed to investigate again after.
No, you see, that doesn't, that's why I said it doesn't punch a hole. You see, from the Thana, when when an incident occurred, some people may rush into to the scene of crime and then say and come back. And then when the OC gives them a power to investigate, he investigates.
Yes, exactly. Lordship.
So therefore, merely because somebody said that I went there at the place of occurrence on the basis of GD entry, the GD entry was examined, was exhibited. It says that 3 people went there.
GDNT, extra GDNT lordship, page 129. Lordship, may kindly come page 20.
129. Yes.
Extra copy GDNT lordship. Now, one Ratul Das, son of Lolit Das, Robiram Das, son of Praveen Das, Prafulla Das, and Sri Funidhar Das, P.S. Kharwad and Boroma have appeared at this PS taking a 10-inch long knife along with them and verbally informed that they have killed a person by name of Govinda Ramsheri by hacking on his neck. Him on his neck. Accordingly, on finding some blood stain on their body as well as in the knife, it can assume that they were murderer, and therefore, after seizing the knife from their possession, they have been kept under the jail custody, guarded by the Sentry Constable. Next, I, SI Sharad Das, have made an effort to proceed to the place of occurrence along with the staff. Next, letter.
93 and Praveen also went.
Yes. 399. Now, SI Sharad Das, Praveen Das, UBC, E. Soikia, 14 April 1 section AISF, present in the PS honorable CI SLB, who have already arrived at this place of police station, proceeded to Tharwasarali, that is the place of occurrence. ASI Ganakanta Das remains in the charge of diary. Now, Lordship may come to the evidence of PWPL. The person of the Lordship PWPL. The second paragraph. Page 20, Lordship, second paragraph. I reported incident to the SP of the district as well as CI. In absence of the OC of police station, the SP of the district directed me to investigate the case. Quite different the statement made in the extract of GDNT and this person of the PW5. PW5, as per the question of PW2, he said, according to him, that his father was not there. You are the OC. If OC, since OC was not there, if he informed the SP. Accordingly, SP directed him to proceed for investigation. Going in extract of GDNT, it is clearly reflected that SI OC Soladas made a GDNT, and accordingly, he proceeded for investigation.
No, see, you see, substantive, we have to evaluate the substantiveness of the what do you call the admissibility of the evidence. Correct. Now, let us say that there are discrepancies in the appointment of the IO of the case, in the person who has lost the GD entry, a person who has been told about the incident, recording of the incident, whether that will be fatal to the prosecution.
If we struck off that portion of the case, there is no case at all of prosecution. Prosecution cases only on the basis of the point that 3 persons surrendered in the police station, accordingly, our formalities are done. And if we not, no,
You
if
see,
we not-
that can't be demolished.
because if that can be demolished, then Lordship has to also consider that the
No.
material contradiction.
That will not be demolished because of the fact that the IO, you do not put that questions
No,
to
we have-
question the veracity. No. you see, that part of the evidence becomes final. It can't be questioned. Merely because there is a circumstances which is contrary will not evaporate the evidence which has already come on record.
Already come on record on a person of the prosecution, there was no loss of independence in this exam. Only the police person who were present and one the PW5 who is also a scriber. He just wrote the FIR. The informant himself also stated that he even doesn't know whether he lodged any FIR or not. So if the person who himself lodged the FIR has no personal knowledge that he has lodged the FIR,
You see, does this change the what you call factum of crime?
the only thing is that this person will never surrender to the police station. They were arrested, they were picked up from their home, and they were produced in the court. This is the actual fact. That is why I'm Lordship insisting on this point. If Lordship doesn't entertain this contradiction, then Lordship, I have no case.
No,
And
no.
if Lordship
No,
considers
you
this
see,
point, they have no case.
For that contradiction, there must be addiction first.
Yes.
Where is the evidence that you were picked up from your home?
It's on the record, Lordship.
Where is it that you have picked up from the home?
I have stated in my Lordship's statement, Lordship. In Sasik also, Lordship, it can be ascertained that they were arrested also. They have not surrendered, they were arrested.
No, arrest and surrender are two different things.
Yes. If Lordship, we were arrested, then the question of all this Lordship surrendering and producing this knife and all, it will not.
No, don't worry about those things. You see, what happens is that, let us say the police has called you for a preliminary inquiry. In the preliminary inquiry, you are called in the police station. And then they ask you questions and then they arrest you.
That is different. If I voluntarily appear in the police station and.
No,
surrender,
I'm just giving an idea. So therefore, you see, coming to the police station, you are now saying that you were
arrested.
picked up from your home, correct? So some witness must give that deposition that he was picked up from the home.
Because those
Number
persons were
one.
not examined by the police during investigation of the
No,
case.
no. You see, after this DK Basu, when a person is produced before the court, on that day also the questions are asked. It was not no evidence was led to show. You see, Mr. Kalita, there are two distinct what you call circumstances. I'll tell you. Number one, in an appeal, we are not required to visit the case diary. That is number one.
Yes.
And this principle is based on the fact that under the Assam Police Act, Police Manual, as well as under the CRPC, the case diary does not form a part of the record. Number one. So therefore, case diary is something which we will not see. Although we have seen it once because you are a legal aid counsel and you have been referring to it, we have seen the case diary. But number one, you are not bound to visit the case diary. That is first. Second is that when you get an opportunity before the court to give evidence, there you don't read those evidence. Correct. So your plea is not supported by any evidence to show that that you have been picked up from your home or you have not surrendered. The fact that you have not surrendered will require evidence to be recorded. Otherwise, how will we arrive at a conclusion? Because unlike Sanjay in Mahabharat, I can't see the fact which has already occurred. I can't travel to 2011 and find out what has happened, except for that's something which is reserved for Sanjay in Mahabharat.
Lordship, what I have learned in my practice period also. In criminal jurisprudence, Lordship, the accused are not required to give any evidence. Everything has to be done by
It's okay.
So judgment of another appeals court.
No, I'm not saying that you should have you should lead any evidence,
Lordship,
but it is your plea. I fail to understand. You see, there are two things. Number one, onus of burden of proof and onus of proof. You will take a plea, and the onus will be on the prosecution to prove it. Is something.
but it never ceases.
So that's what I'm saying. You see, you take a plea, burden will remain on you
No, Lordship. Burden never ceases. Burden is on the prosecution in all proceedings.
for your plea also. Therefore, Therefore, the Ms. Bhuyan, learned APP will number one know beforehand what plea or defense you will take and lead evidence. You may take a plea of alibi in your 313 statement. So she will know in advance that what plea you will take in your defense and then lead evidence that on that day he was present. That is something very ridiculous.
That is ridiculous, Lordship. The thing is that plea of alibi is different. So if I take a
No,
plea of
you took a plea in 313.
Lordship, that is
Mr. Kalita, no point what you call beating the bush here and there. In your 313 statement, you have read out that you took a plea of alibi. And you say that it was the burden of proof of the prosecution.
no.
Now, please tell us, PW 1 to 12 were examined. Who would have had premonition that you will take a plea of alibi and then lead a proof? That's why I said that about the moon. Supposing I say that I was in the moon, the prosecution will not be able to prove or disprove it.
Prosecution has to prove their case on the basis of the record or the materials collected during investigation. No additional evidence they cannot bring thereafter, except for additional search. They have to prove their case on the basis of the material collected by the investigating officer.
Correct.
Yes.
So now you see in an appeal, you are making an argument that number one, you did not surrender. You were picked up from your home. Now please tell me how on earth would Ms. Bhuyan, assuming that she was earlier a trial court APP, would have known that you will take the plea and she will lead an evidence to that effect.
That she doesn't require to know also. The higher duties, the duty of prosecution is only to, on the basis of the materials on record, she has to prove the case that yes, it is the case, it is proved beyond a reasonable doubt. That is their duty. There is no lordship. She doesn't require
Correct.
to know. But
Fair enough.
If I took any plea lordship, then I have to plead. In prosecution, in criminal trial lordship.
So
nothing has been required.
ultimately, you have admitted that your plea you will have to prove.
No.
So
no,
therefore, please
this
prove
is-
that you were picked up from your home.
Yes, I was picked up from home, and they have to clearly establish without the pain of doubt that yes, no, they were lordship, they have surrendered, and accordingly they were arrested. Subsequently they were arrested.
No, Mr.
This-
Kalita, not impressive argument.
No, lordship. this is
PW 1, PW 4, PW 7, PW 9, PW 11, PW 12 all say that you surrendered.
First, because PW4 is the police person who was present at the police station. He is not an independent witness. PW6 is the driver.
I'll just ask you a question. You can, we'll rise for 5 minutes. There are 30 friends of yours sitting behind. Kindly ask them whether they casually visit the police station and and be there in the police station to be a chance witness to somebody surrendering and somebody independent witness sitting in the thana. Nobody will go into the thana and sit.
That is why lordship. Nobody will go to the Thana.
So therefore, in the thana, it will be only the police who will say that yes, he came and surrendered. Will it be disbelievable to the prosecution?
Definitely lordship, it's happened lordship sometimes because I am not lordship in this case. I am not saying anything, but there are also some cases which are made on those cases are made out by the police itself. lordship.
Police, you see,
That is-
let us, you see, many people may not appreciate what the police is doing, correct? But does it mean that in this case also they have done something wrong? Picked up a innocent person from outside, made him surrender with a knife having a blood stain. Because if you say that, it's your burden to prove, Mr. Kalita.
Lordship, if lordship only consider that part, then lordship has also to consider that two person who himself surrendered before the police station and said, yes, we also want to confess before the court. Why those were not party by the prosecution? The prosecution has to establish why they were discharged from the prosecution.
Correct. You go through the case of that what do you call BMW case of Delhi. Correct. In that case, what had happened was that somebody who was driving the BMW killed a person in the road accident. Correct. It's a very celebrated case. A driver came and said that, yes, I was the man who was driving it. And he was convicted. And thereafter, the evidence was led that no, this man took a false plea that he was driving that BMW, and in order to save the owner, he gave an evidence, and then otherwise this man who was driving was then arrested, prosecuted for giving false evidence. Senior counsel who was holding the brief lost his seniorship. So therefore, you see, if given an opportunity, everybody who is somebody will bring people to say that yes, no, I have murdered him, not him. I was there, I murdered him.
Just in news also, I have seen regarding the case of in that.
No, that's
SI
why I
case,
say,
SI case. Some person said he has-
will that be enough? You see, the person's background is that he is a surrendered NDFB.
this person was a NDFB also.
Yes, he is an NDFB. So he can be independently thinking. I'm not accusing him, but he has the ability of what you call creating a what you call a substitute offender. It can't be ruled out. We are not accusing you, but you see, status of the man. That's why I compared it with that BMW case. People are ready to give evidence.
They are different cases.
Stand for the accused person. Take the blame. Go in for a few years, and the family is well taken care of. There are Hindi movies also on that.
Yes, that is what I'm saying. There are different cases also. The standard of proving in criminal cases also different courts have differently.
We'll take a break. Just
That's-
because this doesn't impress us. This.
প্রিন্সিপাল ফলো করো না এখানে submission is the process. Hereby, the prosecution has decided to take the percentage case because no independent was there. They have examined and two three persons who will be examined they will also has said their evidence is as evidence that they have seen nothing. Just stated that we have heard that so and so was killed by some person. They or none of the prosecution officers named this person that this person had killed this person. Number one. Number two is that the Sydney County case 17 that's case made. This was also salary as statement as Joseph reduced from the first sheet as well as the evidence of other cases. This was a salary and surrounded by different shops and lawsuit houses. The place of occurrence as indicated at is say A. Nearby A lawsuit, there is H and G. G and H in next page also is mentioned G and H. Here number G indicate the grocery shop and suburbs. Indication G lawsuit of place of occurrence. G is the lawsuit store of suburbs who himself signed it. Page number 118.
118.
G is the grocery shop of suburbs and H indicates cycle store of defense service. None of this person was tried to even take the record as statement by the prosecution. It was quite formal lawsuit, investigation quite formal, and Sasi was laid lawsuit at the whims of the IOR, not from the evidence of statements of other persons, witnesses.
Yes.
Number 4 lawsuit. The statement, confessional statement It is at page 13, 130, 113.
113.
113 also. I'm reading the verse statement. Around 2:30 p.m. on 17th to 11 Sunday, I was standing by the roadside at Kharwazar shop, which Robiram does after leaving home for work. After a while, the disease Govinda came here. At that time, Profulla Das too came here. Govinda had a quarrel with Profulla Das on the previous day over some matters. Because of that quarrel, on the day of occurrence, Govinda said to Profulla, "Have you come here to assault me?" Govinda got engaged in a scuffle with Profulla and assaulted him by holding his neck. Thereafter, Govinda assaulted Robiram also. Thereafter, Govinda came near me and held me on the ground by pushing me. I punched Govinda in anger. Robiram also punched Govinda. Just then, Robiram bought a knife from somebody and hacked Govinda's neck. I was also assaulting Govinda at that time. After hacking Govinda, we came to police out of fear. We brought Govinda's bicycle and my bicycle to the police station. So from the statement of this person who has confessed, nothing can be ascertained that if there was any predetermination of this person that they are going to kill this person. And also no statement was made by this person as who produced the knife before the police station. And police also not mention anything in the Sidra list as well as the Sasit also, who has produced the knife. A knife cannot be produced by two persons. That has to be definitely produced by one person. And no fingerprint was taken. The person who also produced the knife in police station. The person who their fingerprint was not taken, that it was not sent for FSM also. So also that cannot be a certain who also actually killed the person. This person never also present here in the place of occurrence. They will pick up subsequently also. And also firstly taken in this case. Number 3, regarding lordship asking me the plea of eligibility, what is my stand is that lordship, I have given lordship list of books lordship. 2016 SSC lordship again.
Did he put again?
Sixteen SSC, yes, 418. Lordship में काफी relevant paragraph is 424, paragraph number 11. मैं read the paragraph. 11.
11.
Short paragraph. 7 lines.
Yes, please continue.
It is a cardinal principle of criminal jurisprudence that the guilt of the accused must be proved beyond all reasonable doubt. The burden of proving each case beyond all reasonable doubt lies on the prosecution, and it never shifts. Another golden thread which runs through the web of administration of criminal case is that if two views are possible on the evidence adduced in the case, one pointing the guilt of the accused and another is innocent to his innocence, the view which is favorable to the accused should be adopted. So, here is a case also. Can presume that yes, since they have surrendered, they have committed the crime. but this is not the case at all, Lordship. We were picked up, Lordship, subsequently we were arrested, and none of the prosecution witnesses has named this person, Lordship, except the IO that this person surrendered before the police station and they were, Lordship, arrested. So from this evidence of this prosecution's, Lordship, it cannot be, Lordship, convict the person on the basis of the evidence that is by the prosecution. Then I would be, Lordship, acquitted, Lordship, for the, my humble submission, Lordship. And my colleagues are there, Lordship, there is. I'm obliged, Lordship.
Yes. Your name?
Because my name is Profullo Das.
No, your name.
Of people. Myself, Vipul Bhagwan.
Yeah.
For Profullo Das.
Yes.
Because I am one of the FIR name accused in this case, myself Profullo Das. And in the FIR, 4 persons were named, and which we were seated, Profullo Das, Robiram Das, and Rahul Das. Now, Lordship, I will not repeat what my learned friend has already submitted regarding the deposition part, but I just the leave of the court want to read once page number 113, which is the statement recorded, because as appears from the entire case, that it is a case where confessional statements of Rahul Das is relied, and another circumstance is that all the 3 persons surrendered before the police station with a knife stained with blood. That much. And that effect police has laid. But prosecution has laid certain evidence. This is the only circumstances, because it's a case where no eyewitness is available. Now, if we go by the statement, it is in 113 page number, so it reads so. Around 2 to 2:30 p.m. on 17/4/2011, Sunday, I was standing by the roadside at Kharwajhar shop with Robiram Das after leaving home for work. After a while, this is Govinda came there. At that time, Profullo Das, that is myself, too came there. Govinda had quarrel with Profullo Das. That is myself. I had a quarrel with him. On the previous day, over some matter, because of the quarrel, on the day of occurrence, Govinda said to Profullo, inverted within, have you come here to assault me? This is the statement. by the deceased. Govinda got engaged in scuffle with Prafulla and assaulted myself by holding his neck. Thereafter, I did nothing. Thereafter, Govinda assaulted Raviram. Also, thereafter, Govinda came near me and failed me. Now, who made the confessional statement? He was also assaulted by the deceased. Failed me to the ground by pushing me. Then I pushed Govinda in anger. Raviram also pushed Govinda. Just then, Raviram brought a knife from somebody and hacked Govinda's neck. I was also assaulting Govinda at that time. After hacking Govinda, we came to the police station. Out of fear, we brought Govinda's cycle and bicycle to the police station. These are the another cycles which were brought. Now, considering the content, it appears that there were three accused, we three. Then another affair named Saburu was not there. So why his name is not there? Now this question, prosecution probably has not brought any fact, on any evidence, whether actually the fourth accused, apparently, was present or not. From the content of this 164, it is apparent he was not there. Then again, it is a gray area why that person surrendered in the police station on 19th. So that fact is a missing link in this case. The person named in the FIR 164 says only about 3 escaping him. And if we go by the police statement, IO statement, another fact comes that that fellow force accused also surrendered on the subsequent day, that is on 19th. So this is one point. Now, if we see the content, it appears that the first QRL is on the previous day is with me, is Prafulla. What is said by the appellant Ratul, who made the confession that I had a quarrel with the deceased on the previous day. But here it appears that deceased came and said, have you come here to assault me? From that line, the entire incident started. He comes and says me, have you come to assault me? Then he started scuffling with me, if we admit this. Then gradually he attacked the second accused, Raviram, then another Ratul also. So I was the beginner, that means from me it was started. But whether prosecution has brought any evidence to the effect that I had a quarrel on the previous occasion, answer is no. None of the witnesses, not even my father, mother, parent, not even father of the deceased, who is PW1, has not even referred that I had any previous quarrel with the deceased. That is also not stated by PW1, happens to be the father of the deceased. Now, this is one part. So, from this 164, corroborated by our surrender, this is the only case. Now, to that effect, my submission is that if we go by the impugned judgment, in page number 87, why I have been convicted is reflected in para number 73, page 87. It is page 87 and para 73 of the impugned judgment. So far as Prafulla Das is concerned, at the cost of repetition, it is already proved that he, along with accused Ratul Das and Raviram Das, within half an hour of the occurrence, voluntarily surrendered at Boroma police station with material exhibit number 1, blood-stained knife. There was also bloodstain in his wearing garment at the time of surrender. At the police station, exhibit 4-5 confessional statement of co-accused Ratul Das also proves that accused Prafulla Das was very much present. explanation is I was present at Harwajan Shop. I was present. What the learned trial judge found. On the 11th time of occurrence, he offered, now another link we got is he offered false explanation in 313 CRPC statement that they did not surrender at Boroma PS. That is one of the reasons that I falsely stated what is considered by the learned trial judge that I denied the surrender part. Rather, police apprehended them when they had gone near to the place of occurrence. That was in 313. And the learned trial judge also considered that due to this false explanation, that formed the another link. And 74 reads, the said false explanation on part of Profullo Das coupled with the established fact of voluntarily surrender within half an hour of time of occurrence with bloodstained metal exhibit 9 unerringly pointed to his skin. In committing murder of Govinda Ramsiar. So, para 73 and para 74 fix my presence and 313 I denied and followed by surrender in the police station are the only reason of convicting me. Now, unlike Robiram, that Ratul has confessed all the main allegations were pointing towards Robiram. Some minor allegations, inculpatory statement has been made by that accused Ratul that he also engaged in some pushing, pulling like that. But killing part is, which is the main inculpatory part of killing a man, that part is targeted to the other that is Robiram. So main, if we say that whether this much of inculpatory statement that like presence or pushing, pulling, and the main part has been pointed out towards another accused, how it has to be considered. That is one fact. Now, so far I am concerned, I am not also in pushing, pulling on my part in the confessional statement also. There is nothing, just simply one statement in the 164 statement that I have a previous not meeting of mind like that. Now, in the entire prosecution evidence, there is nothing that there is a preconcert that if we read that statement of 164 statement, it appears that the person making the 164 statement came, then Robiram, then almost in the same time, myself and the deceased came to that place. But there is nothing that there is a preconcert. We will meet together. There's a planning that we will kill, because yesterday I had a fight with him. You are my friend. You will be staying there, and we will come to that, and we together will kill him or beat him like that. That part of evidences are lacking. Now, in which section I am implicated, that it is 34 only. Because of 34, whoever participates in the crime, he may be punished in the same footing. So by virtue of 34 only, otherwise there is, apart from these circumstances, which is applicable to all, I am also facing that much, except Robiram has direct implication that he killed, and my implication is that just I was present. But more than that, nothing is there. So now, if we go by 34, 34 reflects common intention is required. Now, 34 definition, if we read, acts done by several persons in furtherance of common intention. So to attract 34, we need common intention. Now, if we read, when a criminal act is done by several persons in furtherance of common intention of all, each of such persons is liable for that act in the same manner as it were done by him alone. So that is understood. If 34 is there, I may be punished in the same footing. But here, common intention, if we go by in a comment, for common intention is proved, but not overt act is attributed to the individual accused, and section 34 of the code will be attracted as essentially it involves vicarious liability. But if the participation of the accused in the crime is proved and common intention is absent, 34 cannot be invoked. In other words, it requires a pre-arranged plan or presupposes prior concert. Therefore, there must be prior meeting of minds. So my submission, whether prosecution has established that prior meeting of mind, all on a sudden, one person comes, sits beside the inside within the road, then second one come, then third myself came, and at the same time, this disease came, and there is no ignition on my part, no start on my part. He comes, oh, have you sentences exactly like that? Have you come here to beat me? From that sentence on part of the disease, everything was started. And 164 is also silent that as to where we tried, we attempted to kill, we assisted to kill. And also in the judgment, if we, para 73 says, it appears that my presence. So Lordship, my, so for Profulla, the stand, I think 302, since 34 is the only section to drag me, in my submission, 34 should not be attracted. Back, probably it will not come. And he may get some benefit at least. And rest part, Learned Friend has already submitted. Other part, all facts are same. And so far, 313 statement, to Robi Ram, additional question was put because allegation was directly towards him, and that question is not to me because there is no such incriminating part also. For that reason, probably that question was not put to me, but that could be put also. So that much, Lordship, my submission. Rest are I will go by. It is covered by my predecessor submission. Yes.
Yes, Mr. Dar.
I am the person who has confessed. And subsequently in 313, I have written the confessional statement. I have stated that I have not given any confession. Even though if we take the confession, which is at page 113,
Yes.
at 113, I have categorically stated that I have only at the instigation of the disease, I have given him a punch. That much only, and I have given a statement, although I have retracted in the 313 statement that I have not given any statement. Now the duty of the prosecution side was, or the court was to ascertain the truthfulness of the confessional statement. Whether the prosecution or the court has ascertained the truthfulness of the state confessional statement, when I have stated under 313 that I have not given any confession that after 2 days of the thing. So in my humble submission, that part was not done by the court. The truthfulness of the confessional statement. Now, this, if we throw the 313 statement of the accused, which is page 45. It starts from 42. Question number 11. Or 45, page 45.
Page 45.
Page 45, question number 11, it was put PW 11 further testified that on 19/4/2011, we were produced in her court from jail for recording the confessional statement. Thereafter, she explained the provision of 164 CRPC with warning that you were not bound to make the confession. In the event of making such a confession, the same would be reduced into writing and would be used as evidence against you. Despite such warning, you made the confessional statement by the exhibit 4. What have you got to reply? So the reply was, no, sir, the deposition is false. So it's a detected confessional statement. Now, the learned trial court has taken note of the this confessional statement, which has been corroborated by only by surrendering part of the three accused persons. Only corroboration is surrender. No eyewitness, nothing on record, only part is surrender of this person and the confessional statement. Now, whether this confessional statement was testified by the trial court, whether it is done truth or not, that has not been done by the trial court. If I may I, take your lordship to page 61 of the judgment. Here, an argument was made by the defense counsel that the confessional statement made by Ratul Das cannot be appreciated in evidence. Paragraph 13, page 61 of the judgment. As much as there is no signature of Ratul Das thereon. So, from this type copy, we are not able to ascertain whether there was any sign of Ratul Das in the confessional statement.
Is there.
So this plea was negated by the trial court. Now, the only reason,
You want to look at the statement?
but my friend with me, because the signature is there. My lord, apart from that, that confessional statement recorded by the Dalit trial court session judge, which is page 109, the questions put by the learned session judge as well as the time of reflection, period of reflection given. I'm reading from page 112. So that part I'm not going into the signatures. 112, the learned trial court has, while recording the confessional statement under 164, recorded that I have placed the accused under.
Okay, in the confession statement, there's one circumstance you must know, but it is not fatal so far as we are concerned. In the fourth page
Yes.
of the form, the space is too small. And therefore, in the back page,
There,
the statement is taken. There, the signature is not there. It would not be fatal because in the fifth,
That previous statement.
because in the fifth page, again, there is a signature. So continuity, there is a signature, but back page was
Probably
left
that is
out.
why the legal aid council has made that submission that there is no signature of Ratul Das in the confessional statement.
No, but it is there. The back page, if it is missed, it doesn't make a difference because in the pre-page, there is a signature.
Now I am on the period of reflection given to by the learned session judge. Page 112. I have placed the accused under the supervision of the Superintendent District Jail Nalbari for reflection treatment from 18/4/2011 to 19/4/2011, which is equal to or more than the period for which he was in police custody, and ascertained that the investigation agency did not have the touch with the accused during this period. The accused is again brought before me on the date 19/4/2011 at time 11 AM. And once again, he was explained the particulars of 164 CRPC, particularly those mentioned above. And on being satisfied, he is a fit state of mind and prepared to make the confessional statement voluntarily, his statement recorded, which is as follows. So on, since 18 to 19, he was supervision of the Superintendent District Jail, and on 19th he was produced, and on 19th itself he has given the statement. So whether this period of reflection was sufficient because he was produced from the jail custody, and on the same day, without any giving any time of reflection, the trial court has recorded the confessional statement, which he subsequently he has denied. So in my humble submission, so there must be some
That,
before.
that is there. My sister has pointed out, page 100. From page 109, times are given. 3:30 PM. Because normally, you see, the experience is that in the trial court, this confessional statements and all, they are not recorded in the morning time. The magistrate will have a lunch and then they will call the witnesses or any other recording of evidences which or deposition of complaint cases. They are normally recorded post lunch. After the bail matters.
That is there. I have asked the accused in detail relating to his detention after arrest, and he stated he was arrested at place Barama PS at about 2:30 AM and should be PM, then it's AM. Then it goes back to morning and detained at place of detention police station for about 8 hours from 2:30 AM to 11:30, 12 PM before being brought to court. So on 19th, I'm not sure about from this recording, on 19th whether it was giving any reflection period or not. That apart, my lord, the second thing is that I have stated in my confessional statement also that although I have respected it, that the Robiram who has got the knife and he has done the committed the offense. Now, this knife was not never sent for serological test. It is a vital part of this investigation. The lapse on the part of investigation officer, investigating officer, where a case is.
So that AM PM is not a mistake, it is AM.
AM. So he was with the police till 11:30, 12 PM.
But the- so- Arrest for time. Arrest for time, arrest for. You are for which, what is the name?
Atul Das.
Ratul Das. এখন বাকি শোনা এতে
PM.
PM.
That is why sometimes the type copy do not really.
No. The magistrate has recorded AM. But on consulting with the
AM means
with the case diary, we find that the arrest and seizure is 3 PM, 3.05. .05 PM. So
on 17/4/2011.
3.05 PM was the time of arrest. Time of seizure also is
17.
same.
Now I'm asking.
We'll continue some other day. Because we have a meeting right now. Yes,
Lucan I was sitting us in that case, so he is not in a position to appear before the finally on the case proceeding.
let me adjourn because second half we are not sitting. It will be adjourned.
And may it be posted on the last week of November. The opposite side has consented for the date. You may make this last week of November.
Last week of November. Give a date in last week of November. Okay. Okay, they'll do it. Yes, we have to give a date.
Can it be day after tomorrow, Moshe?
Not a very long date. Just see that you award the date of special bench. Ten. Okay.
That's part of it.
Yes, Father. Hearing when Mr. J. Kalika, counsel for the legal aid counsel for the you're amicus, okay. Oh, okay. Gives him counsel in criminal appeal. But 32 is a jail appeal. But is it this counsel? Okay. Mr. J. Kalika, counsel for the appellant in item 3. Item 4, Mr. B. Bhagavati, amicus curiae. And number 5, Mr. A. Dhar, amicus curiae. In item 3, right? His argument is concluded, reserving right to reply. This we may have another ADP is present. She will be heard on the next date. Same order in item 4. And in item 5, right, the submission of the government amicus curiae is inconclusive. Response was must be made under senior counsel and ADP for the case present. Separate orders, huh? Yes, you wanted to say something?
Whether
Yes,
the
yes.
single bench is sitting at 2. From my own colleagues, your lordship has expressed there is a meeting, so everybody is worried that.
No. The meetings are part of the part of our routine.
Second time.
Okay, 19 and 20.
Other everybody is there, my lord, I for my. Anyway, analogous my.
It's analogous. We have to do it. When do you want?
They have to.
Day after tomorrow. Okay. We are keeping it on Friday instead of day after tomorrow. So there is again a division bench, a different division bench on the day.
Friday, 10th.
10th. List on 10, 11, 2023 as paid for by Mr. H.R. Chaudhary, Senior Counsel. appearing in BA 3415 of 2023. Yes. Give it to the court master. He'll have to make adjustments. Please give it to the court master. Okay. Yes.
Speaking of two benches, number 23 also.
Yes.
Already put number 23, I have got item number 2. There is some urgency. So you want to fix the button. If it's possible on time. Actually, that was fixed on hearing a day, so that was fixed today,
Okay.
considering the nature. So I think if it is feasible, your lordship may fix it on next Tuesday.
Next Tuesday.
Yes.
Item number?
Item number 2,
Item 2 of court number
23.
23. Mr. J. Abidin, counsel for the petitioner submits that there is some urgency in the matter. List on so and so. Okay. Thursday.
16.
No, 16th, there's a special division bench. 15th? 15th? 15. There's again a different special division bench on that day. So 15th.
Of this bench.
Okay. Listing on Friday then? Okay. So both sides are duly represented. Mr. K. Goel, and standing counsel for the Higher Education Department, submits that he has received the records and needs some time to go through it. List on Friday.
Ballot this Friday. 10th.
10th.
Bibliography.
This court 7. Earlier one was
10, 1, 2, and 3.
yes. No, that first part was over. Now this other two writ petitions were to be heard. That we did not hear on that day. The limestone and others that we did not hear.
No.
So
These are not here. These are not here. These 3 matters not like. Only.
no, we had
One is whether regarding
no one the one item I already reserved that judge for the order. This is the bunch.
yes, because that matter has been separately done. That limestone matter has been separately. That has not been taken now. Here one is transportation, other is my lord in that crushing machine permit, whether it's.
So that part you can argue if you want today or some other day.
Oh, that I would my lord, because I'm saying my lord that.
No, because on my note I have already referred to 50 this
5052.
5052.
Yes.
So others I have not made a separate record. Okay, when? Next week. Two weeks. Okay. Because here my, what you call, this I went through in this vacation and I could make my notes complete. But the other two, I have not made a note. So you agree to a date, both of you. Consult Mr. Saiwala and fix a date.
Let them suggest, madam. 14. 29.
When?
29.
29th, okay. And this, Mr. Jain Saiwala, Senior Counsel, assisted by Mr. P. Deka, Counsel for the petitioners. And Mr. A. Barwar, and it's Standing Counsel for the Forest Department. You are also there? Oh, for us, okay. In this bunch in this group of three petitions, WPC 5052 of 2022 was hearing in WPC 5052 of 2022 was completed. Accordingly, the matter has been listed at the instance of the court for hearing the parties on in connection with WPC 1357 or 2015 and WPC 6544 of 2022. Correct? Next para. The Learned Standing Counsel for the Forest Department has submitted that Mr. P. N. Goswami, under Additional Advocate General, who was to argue in the matter, is indisposed and accordingly placed for an adjournment. Prayer is allowed based on 29/11/2023 for hearing the other two petitions.
Lordship, the engaged counsel, Mr. A.R. Ray is out of station. So Lordship, the possible matter for the Lordship.
Okay. Listed on Monday. And on Monday is holiday, 14th. It goes to 15th then. Both sides are duly represented. As agreed to by both sides, listed on 15/11/2023.
I have that.
15.
M5.
Yeah.
Yes.
My lord, on the last application, my lord, it has been directed to file the application in the TLC. Yeah, and my lord, by the director.
Inspection.
Yeah, but they have, my lord, assured the board of court that they have received the instruction on that particular day, my lord. But they are not filing the.
In this case, Manoj, I have filed one IA to get the order dated 23/7/2021 because of stay order that petitioner did not receive salaries. He has
Okay.
already
The Deputy
received
Commissioner has not filed the affidavit. Who is appearing for the state? No one. No. State was directed. Deputy Commissioner was directed. State district scrutiny committee. Nobody is there for the state. You for the education department. No, the state, it's the deputy commissioner who's required to file an affidavit. GA Assam in item number 5. GA Assam. Give a scroll for GA Assam in item number 5. After some time, let him come. We'll You file your affidavit, then we'll call the personal appearance of the officers. But this is they are claiming regularization.
Four categories that give us a very different. One is this category is they are recommended but discontinued. That is why they are services around the world.
No, but this, you see, without the affidavits, you want us to adjudicate without, on the basis of, without an affidavit?
That's then I will bring it on back. No, I have not received a step on the. I'm aware of this.
No, you see, this is a writ petition 21. If they don't give a response, let the officers be here. And they'll have to, they'll watch the proceedings. So suggest a date of personal appearance. No, we'll give you time. Suggest a date of personal appearance. You can file your affidavit 2 days in advance. Then you don't have to come. Otherwise, you'll have to be here. Suggest a date. Fourth of December, okay. We are fixing it on 6th for personal appearance. You can file the affidavit by 4th. Correct? Mr. B.P. Bora, counsel for the petitioners, and Mr. N.J. Khatune, Leonard, standing counsel for the education department. It's a school education department. School education department. Next, the learned standing counsel for the school education department prays for some further time to file affidavit in opposition in the matter. Full stop. This is next para. This is a writ petition of the year 2021, and notice of motion was issued by order dated 1/11/2021. Full stop. While granting time to the school education department to file their affidavit in opposition, it is provided that in the event the affidavit in opposition is not filed within 4/12/2023, the following officers of the school education department shall be personally present before this court with all the relevant records on 6/11/2023. So the officers whose personal appearance would be required on failure to file affidavit in opposition is: number 1, Commissioner and Secretary to the Government of Assam, Education Department within bracket elementary. Number 2, Director of Elementary Education, Assam within bracket respond number 2. Principal Secretary, Finance Department. No, Principal Secretary to the Government of Assam, comma, Finance Department within bracket respond number 3. And Inspector of Schools Dibrugarh within bracket respond number 4. Next para list on 6. 12/2023 for personal appearance of the officers in case affidavit in opposition is not filed.
Presently, madam, who is only secretary of-
Only secretary. Okay, secretary, not commissioner. The secretary. Okay, there must be some designation, principal secretary or no, only secretary. Okay, okay. Next, para the learned standing council for the school education department is permitted to send a downloaded copy of this order to the authorities. Bring the order to their notice. Okay.
Item 5.
Yes.
I need to explain.
What is this? Salaries have been stopped. That is what Ms. Devi is claiming.
That order, madam, since did not receive the salary. He has been selected at the time of the selection as a Hindi teacher. He was the second teacher.
Just a moment. Your service was not provincialized.
His service is not. Respondent has already been provincialized. And she was getting salary because of he filed a case. That's right. He wants my.
Acha, you are the writ petitioner. Oh, okay, just a moment. Oh, okay. Is it right? Just a moment. Mr. Katania, you are appearing for the elementary education department. You see this order of the court of 23/7/2021 merely says that the provincialization shall not be given effect to. But how the salary is stopped? No, it's okay. Don't give that effect. But salary must be paid if the if
Only after the incoming is entitled for the salary.
And he has received after the order, madam, salary has been stopped. After getting the petition.
they are working, Mr. Katania.
Stay working.
So if they are working, you have to pay.
They are not employed. That is, actually, they are entitled for salary. That any order of provision is not given effect to all.
I don't know because if for 3 hours I don't eat, my stomach starts troubling me. If I don't eat for 3 hours, I find it very difficult to sit and concentrate. Can the state have some arrangement with this PDS people and then give them free rations? If no salary, she becomes lower than the poverty line. No, I understand. Then you stop them from coming to the office and work.
Therefore, she's under no obligation to provide. She's under no obligation to provide.
Please, Miss Devi, let me understand. If three of you speak together, I won't understand anything.
We take into consideration the market that is supposed to be on your you are potentially paying the salary for the particular school. Once it's on a stage that installation. Taking her into our service or into our records.
No, but you see, it's a catch-22 situation. If she doesn't come, then you say that she is no longer working.
She need once the provincialization order.
No, but then you issue them order that you are not required to serve, but you are but you will be considered to be in service when the provincialization is decided. No, then then you will raise a issue that she is no longer working and therefore she can't be provincialized.
Once the already done provincialization uphill, there is no question of her being provincialized again. If the provincialization is uphill.
No, but you have to do something. You see, exempt her from coming. Then we understand. You see, there's no official order of order not to come.
Just to the Department of- That is what I was able to understand. A regular appointment. He joins the post and then his appointment is stayed by the honorable board. Is he under an obligation to continue the vendor service and are we under an obligation to continue to pay him the salary? Because that.
No, you have a valid point. You have a valid point. I'm not saying that. What I'm trying to impress upon you is that you see somebody is in queue of being appointed. The appointment has been stayed. The appointment was made in favor of Ms. Devi, but it was stayed. Now, the fallout is that she is not receiving her salary. Correct. The state must take a plea, take up the matter that okay, your provincial has been stayed, therefore you are not under an obligation to come, but you will not be treated as abandoning of your claim or something like that.
The emotional benefits, the company gains every emotional benefit that is all from his food.
No, then you will say that no work, no pay. Then you will say no work, no pay. She did not.
Acting as a teacher under the government, you can state that is on the report. No one works for us during this time, not the respondent, not the petitioner. We pay the salaries, we don't get any service from anywhere. There cannot be this situation in Bangalore.
No, if she is working, you are getting a. You see, the government.
Pay the salary.
The government may not be.
The contribution saying that there was a stay on her provincialization and salary is being paid. You don't even answer to that. So the moment the provincialization or the amendment is stayed, it is upon her not to attend the meetings. And they will be honorable because that this will not act as a bar or it will not act as an impediment in my continuity of service if I win the case in the end of the day. That will be for her to show. But so far as our orders are when they are staying, the moment we pay the salary or we say that she is being allowed to work by us, we have committed a contempt. All said and done, her claim is, all claims to be first decided. When we say that she would be entitled to the salary in between this period or she would not be entitled on the second worker. What is Solar Foundation would be their argument to say that I am entitled to the salary because I continue.
What continues to be said?
Once we say that you are not entitled to the salary, but as of today, the moment I release the salary, is the moment I there's a problem for this proceeding.
This case in the year 2021, till today, they have not filed application. Last occasion, they said that they got instruction. Till today, they have not been filed application. And for that, I have not been received salaries. This is the case of 2021, madam. This, now to 2020, likely to be gone. Only 1 month is there. Now he's outing like this.
What is your instructions? Let us see that instruction.
No specific instruction. That's why. In this way, in some other provision, there is a provision for appeal, the section 14 also. We can very well go for appeal.
Yes, how do you say that you are more entitled to than Miss Devi?
I'm scheduled to her, madam.
Where is that?
Both her language teacher.
Where is that?
I don't find on Excel 5, please, madam.
Page
Page
26.
26. So read it, madam.
This Miss Devi's and serial number?
On bottom, madam, on bottom, the section and bottom. So I am probably, madam, the petition.
Satyanan Bhali is,
Madam, on the date of joining,
yes.
01/01/1994, madam.
Yes.
Madam, there are next is my lord. But on remember 4, Niroda Bora, madam, is the respondent. Niroda Bora, the right side, column number 6, column number 6, Niroda Bora.
Yes.
And the third date of appointment is my lord. 01/01/2023, madam. Date of director. Currently, almost 10 years, madam, senior to her. It will be to the madam. What her language teacher. While police, they have observed some other indications, here a retired person has the service of a retired person has also been positioned. Who has attained that superannuation prior.
No, one mistake here and there would not make it. You concentrate on your own case.
Fine.
You have not issued notice to that retired person, so it's here against him in his absence. So concentrate on your own case. But that is the only point.
My lord, file. My lord, this on page 17, madam.
Yeah, but you're a subject teacher of which subject? How where do I find it?
Assamese subject.
Where do I find it?
My lord, I have filed additional application. I have filed an additional application there.
I have filed an education.
Very good. You are a writ petitioner. You also file an affidavit in objection against your own writ petition. Very good.
But it's against the amount of IA that they have filed. I have filed an additional application
Now, I don't know if I'm reading it wrong.
against.
Unless I'm reading it wrong,
Yes, I apologize.
reading wrong is again something which is very doubtful.
I apologize for that matter. There is not any typical mistake.
Okay,
I
not
apologize.
typing mistake.
Subsequently, I have not repeated the
I was reading right.
my
Okay.
that particular episode in my life. And I will change from 39 more serial number to 6. 39.
No, but this does won't do. You withdraw this and you file it in this IA. Your nomenclature is not of IA. The affidavit filed on 4/8 is not in IA. One mistake I can condone. This is the second mistake. Third mistake, let Miss Devi and Mr. Khataniar see it. You may not like to see it. So just give it. You can peek. If you want, you can peek. No verification in the affidavit. No paragraphs on either on knowledge or on record or on submission.
Allow me, this is clerical.
No, these are not clerical mistake. This is not clerical. You are stopping somebody's salary and then
I will file a paper.
No. Because I have a very bad habit of starting from reading from back page.
That is correct. But I will not repeat the statement with some inadvertent.
Very bad habit. I can't help it. Huh? No, without this and file it, but there's this scrutiny, Mr. Pegu, you'll have to get it. This scrutiny committee's what you call records, it has to be produced. No, not that. But you do some exercise. You see, here in this case, Mr. Das has been able to show that he's about 10 years senior to Ms. Devi. He's 2003, she's 19, sorry, 10 years difference, whatever be the date. So she's admittedly a junior, but her service has been recommended for third teacher. Now she's Hindi, he's Assamese. So both are language. No, but somewhere I saw it was Assamese and one is Hindi.
This is also a language. This is also a language. Even if-
English. So this is an English medium school or a Assamese medium school?
Assamese medium.
That is why I have been appointed as a Hindi teacher because most
So where
of
the school
these
is located?
schools' name is nursery school's name is
In Assamese medium.
Zadapur Savagisa ME school. That is why I was appointed initially as a Hindi teacher because in Savagisa's mother schools they obtained Hindi teacher and he is teaching English language.
From where you are saying that? In the IA. No, you filed in which proceeding? Writ petition or in the IA? In the writ petition. Okay.
His name is Satyanarayan Bharati, my name is Nirodha Bharati.
You are Nirodha?
Nirodha.
Huh, huh.
And he's high because he's the second in school and education and qualification HSLC. He also
You are reading at which page?
52.
52.
Major expenditure. Then he joined 21/2/2004. He joined 1/1/1994. Then lost his educational qualification HSS Hindi Vichara and he passed on the HSL. Percentage additional respondent got 55.24 percentage. Then he got 46.6 and percentage of age of marks obtained in graduation on respondent got 67.500. Then in his he did not get English. No. And he was teaching English. Hindi teacher. He thinks he was here in the year 2019.
Okay, where is your appointment order?
Page 14.
He's a tutor. No, there's a document which is that what is it called? Captured document in that DICE code. Where is that?
That is, that I have referred myself that I have submitted in this, my edition, but this just, bit earlier I have. There is a lot of capture format. Submitted by the headmaster itself.
No, which page was that? The DICE code. Where will I find it?
My lord, page 37, my lord.
Page 37 of the repetition.
And it's additional.
57.
My lord, final page 37, which has been segment of the enrolled by the headmaster.
But then there's nothing showing that you are a tutor in which subject?
My lord, that is on page 39.
Page 39.
Page 30. On serial number 28. Appointed for subject. Some is in English.
Asam is in English and she is Hindi. Yes, Mr. Khatonia. What is your department stand? Here page 39 shows Assam is English. No, but who gets the precedence? She said that she's at tea garden. Then you'll call the seniority. So here also we do the same thing. We are asking the deputy commissioner to be here, Mr. Pegu. If he can produce the records, he is exempted. Number two, the education department officers will be here. If they unless they file their affidavits. You're fixing, when do you want? Suggest a date, there's a calendar, just give me a date. I'll give you 2 days time to file documents or produce records or otherwise personal appearance. 29th November. Okay. Fourth December. Okay, so if by first you don't get the records, on fourth the deputy commissioner is to be present. No, no. That is your call. What I'm saying is that by first you should get the records. Correct. If you get by first, you will produce by fourth. Correct. So if he doesn't send you the record by first, on fourth he will be personally present. And so the education department. If the salary is stopped, they'll have to run. And Mr. B.K. Das, counsel for the petitioner, also heard Mr. G. Pegul, government advocate, appearing for the deputy commissioner, come district scrutiny committee within bracket respond number 3. Mr. N.J. Khatuniar, learned standing counsel for the elementary education department, representing respondent numbers 1, 2, 4, and 5. And Ms. K. Devi, learned counsel, appearing for respondent number 7. There is no representation from respondent number 6N for respondent number 6. Next para. At the outset, the learned counsel for the petitioner 6 leave of the court to withdraw affidavit in objection filed by the petitioner on 4/8/2023 and to file an appropriate affidavit in opposition in connection with IA Civil 3611 of 2023. The software is allowed. The affidavit stands expunged from record on withdrawal with liberty as prayed for. Next para. Considering the directions contained in the order dated 10/10/2023, requiring the district scrutiny committee within bracket respond number 3 to file counter affidavit by 3/11/2023, the court takes an exception to non-filing of the affidavit in opposition by the respond number 3. Stop. Accordingly, it is not accordingly, say the learned government advocate prays for some more time to obtain the relevant records. Next para. Considering the prayer made by the learned government advocate, while dispensing with the filing of counter affidavit by the respondent number 3, it is provided that the district scrutiny committee represented by the deputy commissioner, which district? Jorhat, shall ensure that the relevant records relating to the provincialization of service of Srimati Niroda Bora. Mr. Khatuniar, just tell us what you call the nature of records required, because otherwise they will not be able to find it. Niroda Bora will be no one for them. How do I refer to that specific record so that only that record will come? In respect of Jadavpur, where is the spelling? Where I get it? 28. Page 28 of the writ petition. Name of the school. It is
Cell number 220, 226.
226. Okay, Jadavpur, JADAVPUR, CHAH, Bagisa, BAGISA, capital ME, school. Under BEEO, Central Jorhat. Full stop. The Deputy Commissioner District Scrutiny Committee Jorhat shall take note that in the event the records cannot be produced before the court by 1/12/2023 through the learned government advocate, he shall be personally present on 4/12/2023 at 10:30 a.m. 10:15 a.m. positively, without fail. Next para. The court takes notice of the submission made by learned counsel for respondent number 6. No, sorry, you are for 7. That owing to the interim order passed by this court, her salary has been stopped. The Elementary Education Department is put to notice to positively file their affidavit in opposition in this writ petition by 1/12/2023. Full stop. Failing which the Secretary to the Government of Assam, Elementary Education Department, within bracket respond number 1, District Elementary Education Officer Jorhat, within bracket respond number 4, and the Block Elementary Education Officer Titabor, within bracket respond number 5, shall be personally present before this court at 10:15 a.m. on 4/12/2023 with all relevant records, and be prepared to assist the learned departmental counsel to answer to the court queries. Next para. It is again clarified that the personal appearance is ordered in absence of production of records or filing of affidavit in opposition. Next para, the learned government advocate as well as the learned standing counsel for the Elementary Education Department shall transmit a copy of this order to the concerned authorities, which should constitute due notice of personal appearance on their failure to produce records or to file affidavits. Next para, list on 4/12/2023. Your instructions. Yes, item 9. Oh, you're there. Time being, okay. Time being. Right. Yes. Time being. Okay. Okay, time being. He's on legs. We'll take it out after some time. Okay. Item 11. Yes.
Order dated my lord 28/4/2020, passed by the director. But you will find at page 97, section 24.
Page
97.
97. Just a moment. Yes, you don't fulfill the criteria of school students in the school.
I fulfill the criteria, madam. But then in this case, madam, two schools were established having the same name. And accordingly, after considering all the matters by the Honorable Court as well as by the concerned authorities, madam, my school was declared to be the original and general school. And because of that particular reason, madam, my dice code was not remain open for 2-3 years. Madam. Because of that reason, madam, the dice code could not be inserted in the union dice code, for which the number of students in the enrollments could not be shown by the concerned authority. This is the reason. Madam. However, madam, in the meantime, madam, a correspondence was made by the concerned district officer. She will kindly have a look, madam. At page 96, madam, connection 23. To reopen the dias code, page 96. This is a correspondence made by the madam, district elementary regional officer come district mission coordinator to the mission director. Last paragraph.
Just a moment. What is the name of your school?
My school's name is Malad Dokhin Kodwani Puzai, ME School.
ME school,
ME School. LP School. Sorry.
LP school. So both the school has same name.
But the school has same name, but that school has been declared to be a fake name. There's a order also, speaking order was by the concern of the deputy commissioner. Now they have no name.
Yes, Mr. Katania, how do you resolve this issue?
Regarding the number of students,
So you recognize him as a correct school?
yes, ma'am. Not
No, that's okay, but you have heard Mr. Hamad. He says that once there was a dispute, you don't upload that data.
yes, ma'am.
But regarding the enrollment, it was sufficient enrollment.
That I may be allowed to be clarified. Page 84, election 18. There's an inspection report for that particular period pertaining to the year 2017.
84.
84. This inspection was carried out by the SI of schools. And the number of students from class wise has been thoroughly mentioned. This was conducted on 5/5/2017. By the concern. There were sufficient students. But unluckily, those things should have been reflected in the order.
But we can't have school like that. 14-16 with bamboo pillars and kacha house.
Regarding that school building, nothing has been mentioned in the order.
No, I understand. You see, you have class 1, 2, 3, 4, 5.
Yes.
One with 22/15, 19/12, 21/10. I don't know what 20/18 would mean.
Boys and girls.
Okay, boys and girls. Okay. So you have 13 plus 10 is 23. 23 plus 38 is 51. 51 plus 31 is 82. 82 plus 31 is 100 and 82, 31, 113. 113 and 37 is 150 students. 150 students accommodated in a classroom of 40 into 16.
The reason that has been stated by the state level scrutiny committee, Madam. Roshni will kindly have.
Because I have a low voice, even if I take classes in that classroom, class 5 will hear ABCD, and what you call, I'll be hearing arithmetic, which is being taught by other class. Class 5 is taking up arithmetic. I'll be learning arithmetic, and my ABCD they will be learning. Class 5 students will be learning. This can't be believed. 14 to 16 with 150 students.
The reason that has been stated.
No, that's okay, but can you believe it?
This is as per the inspection report. Since regarding the inspection report.
No, these are all midday scheme, nothing more. 150 midday meal you want, nothing more than that. No, we'll order you to have a first inspection done, not by this inspector of schools. 150 students to 14 to 16. No, his IS would be. You suggest a person who will be doing that inspection. We won't say anything in the order. We just say that the appropriate authority will take a decision, and instead of IS, a senior official will be sent for inspection. Huh? No, I'm not saying. But do it and give us a report within 4 weeks.
This is listed after a long period of.
No, I'll give a date. Don't worry.
But otherwise, I fulfill all the necessary criteria.
It's okay. But this, what do you call, bamboo pillar and Torja house, housing 150 students, something not acceptable. But Mr. Z. Hamad, Learned Counsel for the, just see spelling, huh? Z. Hamad, HAMMAD, Counsel for the petitioner, and Mr. N.J. Khatania, Learned AVP for the, Learned Standing Counsel for the Elementary Education Department, referring to the, all the respondents. Respondent numbers 1, 2, 1, 2, and 6, and Mr. V. Chaudhary, V is victory, huh? V. Chaudhary, Standing Counsel for the SSA, representing respondent number 3 and 5, and Mr. G. Pegul, Government Advocate, appearing for respondent number 4. Next paragraph. The Learned Counsel for the petitioner has submitted that as per inspection report dated 3/9/1996. This is a report of date. A report of inspection dated, inspection carried out on 5/5/2017, comma, the inspector of schools has found the school with a 40 into 16 bamboo pillar and kacha house, and the enrollment of boys and girls in various classes was found as follows: class 1, 22/15, class 2 is Roman 1, Roman 2, huh? Class 2 is 19/12. Class 3 is 21/10. Class 4, 20/10. Class 5, 13/10. Full stop. If they said inspection report is to be believed, comma, about 150 students of 5 classes are accommodated in the Kacha house with bamboo pillar measuring 40 feet into 16 feet. Full stop. Therefore, the school so the director of elementary education shall depute a officer of a rank higher than inspector of schools to carry out inspection of the Dakhin, DAKHIN, Kadamoni, KADAMONI, अर्थात PATHER LP school. Take an appropriate decision on the claim of the petitioners for provincialization. Next para. The learned counsel for the petitioner has submitted that as there was a dispute with regard to the genuinity of the school of the petitioners with another school of the same name, pursuant to a direction contained in the order dated 21/9/2015, passed in WPC 5638 of 2014, the Deputy Commissioner Nagaon, who is also the the additional Deputy Commissioner within bracket education, EDN, bracket closed, Nagaon, from chairperson DLRC, Nagaon, had passed a speaking order dated 19/8/2016, recognizing the school of the petitioners to be the genuine one. It is submitted that owing to the dispute amongst two schools of same name, the data of the school of the petitioner could not be uploaded and captured in the DICE code. It is submitted that because of the non-capturing of the data in the DICE code, the same has resulted in rejection of the claim of the petitioner school for provincialization of service by a speaking order dated 28/4/2022, passed by the Director of Elementary Education, Assam. Full stop. Next paragraph. In this case, the notice of motion was issued by an order dated 30/5/2022, but the Education Department has not filed a response. Under such circumstances, the court is compelled to pass the order as indicated above, so as to enable the Director of Elementary Education, Assam, to conduct an inquiry with regard to the enrollment and condition of the school, so as to enable them to take a fresh decision. and communicate the same to the court. Next para, the legality of the order dated 28/4/2022 would be subject to further orders that may be passed by this court. We can inquire in the meantime. List on 4 weeks. 4 weeks, we fix it on 15/12. 18/12. Next para, the petitioner shall produce a certified copy of the order before the Director of Elementary Education, Assam, so as to enable him, the said authority to take appropriate steps. Give a copy to him also, so you can send. Yes, tribunal judgment, your challenge.
The tribunal, your worship, will find that page 179. Prior to that, my lord, the little background will be required before the tribunal's order.
Yes, yes,
Records are with me.
records are there.
Records are with me.
It's with you. Okay.
Now the respondent number 5, my lord, who opposed the tribunal. He was appointed in 1992 as an assistant teacher in this school, which is a mother Hindi school. The Vansor stage, the school was literally provincialized in 1992. Then in 2001.
Just
there
a
was-
moment. I've raised gray beard, thinking that nobody will trouble me anymore. Trouble me anymore. Gray beard. But now again, you're making me hear things. Yes.
I don't agree to that. Or is it?
No, perhaps he did not see what you call Mr. Majumdar in his 5 years of practice. He has not seen, perhaps.
He always raised a little gray, my lord, here. It was all good.
But wonderful experience with the senior council.
The reply you can read in a moment.
Yes, yes. Hmm?
Very meaty also.
Yes, yes.
What you want to know. They get things more related.
Yes, yes. That is why I wanted to come out. Yes, yes, yes.
992 is the date. but
You've given a list of dates. This is,
Yes, fine.
this I have seen. Raman Jha, appointed as assistant teacher.
Then, my lord, he was allowed to hold the all of the headmaster of the school. That is, my lord, in 2001. To be precise, 23/6/2001. Then
The school was provincialized when?
it was provincialized
2014,
52/9/2004.
14. I am asking this because why this report of joint director of DSE was required? Because if it's not non-provincial school, why did the inquiry go to the joint director?
My lord, in fact, there were complaints to this thing. It could be, my lord, although it was not provincialized, but there were complaints against him. My lord, multi-player of his power and. And as you also told, my lord, my lord, venture school, reservations are to be updated in sector schools, so everything, my lord, goes to the inspection.
Oh, acha, this I missed it out. Okay. Okay.
And this is the opportunity proceeding with the possible fine, my lord, each and every resolution has been approved by the inspector.
Okay. Okay.
Fact, my lord, he is given charge as headmaster in charge, that was also, my lord, provisionally approved by the inspector. That was in, my lord, 26 to 2002. Then, in respect of his education, he was suspended and then he was terminated on 22/8/2007. This is the date of termination. After his appointment, the petitioner number 1, he was appointed as the headmaster of this. That is also prior to provincial. The date is 30/11/2007. Your worship will find that at page 150 of the date. Now, another crucial date is, my lord, the Assam Non-Government Educational Institution Regulation and Management Rule 2007, that came into effect on 29/10/2007, and his termination was prior to it on 22/8/2007. Before this rules 2007 came into force. The provincialization order came in 2014, to be precise, 22nd of September 2014. Now, termination is of 2007.
22/8/2007.
2007, he was terminated. In 2014, when the school was provincialized, then he filed.
But the finding of the tribal in paragraph 30 at page 197-98 is that the order of termination by resolution number 3 dated 22/8/2007 was illegal.
Yes, that is the finding.
And it says that it violated the principles of natural justice, and then therefore the termination was held not to be.
That is the finding. So, my lord, I have two submissions against that matter. Firstly, whether, my lord, the claim of the respondent number 5 can be allowed on the basis of a rule which came into effect after the date of termination. Because the tribunal has discussed now that there is a violation of the that is the basis of the finding. Although, my lord, the standard has been used that violation of the there. So, in 2007, he was terminated. 2014, my lord, the school was provincialized. He filed the petition in 2014 after the provincial after 7 years. And thereafter, this amount will go relying on up to local conduct scheme, except the necessity price. The first thing is, my lord, he challenged the termination is over time law. For 7 years, my lord, he did not execute the bill. And then the rules which have been relied on by the tribunal are subsequent to the date of termination. Therefore, he could not have relied if, and I think your lordship, his findings, there were, my lord, as many as 6 issues framed on the issue number 6. Issue number 6 was whether the petitioner is entitled to get any relief. That was the issue. And while deciding that issue at page 190, paragraph 15 of the Indian judgment.
Yes, just a moment. Yes, 6 issues were framed.
I come to issue number 6 at page 190. The issue relates to air engagement. Page 190. Other issues are maintainability, whether the school was established, whether the teacher was appointed as headmaster of the school, whether the Avadish resigned as headmaster and why, then he joined the for this. Well, consideration of issue number 6 will perhaps be the most relevant consideration. Air review.
Yes.
This issue relates to reliefs entirely by the petitioner. In this case, the petitioner has sought for various reliefs, such as to set aside the resolution number 3 adopted by the school management committee by which the petitioner was removed from service, to direct the official respondents to provincialize the service of the petitioner as headmaster of the school with effect from 1/1/2003, to direct the official respondents to set aside the provincialization of service of the respondent number 4, to grant any other relief which the tribunal deems free and proper in the interest of justice and equity. Though no separate issues have been framed in this case on the legality of termination of service, but the dispute can be decided in this issue by discussing the materials available on record. So far as relief number 1, the validity of the resolution number 3 adopted by the school management committee in its meeting dated 22/8/2007, it may be mentioned that during the argument of the hearing, Mr. M. H. Sheikh, the learned advocate for the petitioner, has submitted that the petitioner was never informed about the charges against him, and even the copy of the resolution by which the petitioner was removed was never served on him, and hence he could not furnish the exact resolution. It is further submitted that while removing him from service, the school management committee has not followed any of the provisions relating to departmental inquiry by forming a disciplinary committee, submitting charge sheet with specific allegations, making inquiry on those charges, and then submitting the report of the disciplinary committee before the SMC for approval and then removal as provided in the non-government school regulation and management rules 2007. So that is his case. It is also submitted that the entire allegations leading to removal are vague. It is also submitted that in the event of setting aside of the said removal being not followed by law, the provincialization of the service of the respondent will become illegal, and in consequence thereof, the petitioner will become entitled for consideration to be appointed as headmaster of the school with effect from 1/1/2013. Then your lordship may come to next page at paragraph 19.
The termination of is of which date?
Termination in 22/8/2007. August, 22nd of August 2007. Now, here I pause for a while, my lord. The respondent number 5 was never appointed as a headmaster of this school. He was only given charge of headmaster. He was appointed as an assistant and that happened on 10 he has to given the charge. So he was never a headmaster of this school. At least my lord, no document has been shown by the respondent number 5, so that my lord he was regularly appointed as well. Then your lordship may kindly come to page 192, paragraph 19. Before going into the minute details of the case, as the whole case is based on alleged non-compliance of the various provisions of Bill 2007.
Given that comparison of that education manual.
My lord, that means 595. This was published in the Assam Gazette on 29th October 2005. and the resolution of termination is 22nd of August 2000.
Okay.
Before going into the minute details of the case, as the whole case is based on alleged non-compliance of the various provisions of Rule 2007, let me first quote the relevant provisions of the above rule. Chapter 9 of the Rule 2007 provides for procedure to be followed in the disciplinary action against an employee under Section 15(3) of the Act of 2006. Rule 17 that has been quoted. Then your worship is keep my lot of findings are at page 192. Paragraph 25. On looking at the facts of the case, it appears that under the order of the SMC, the petitioner was initially placed on suspension, and then by the resolution number 3, petitioner was removed from service. In this pleading and during evidence, the petitioner has categorically stated that no disciplinary committee was ever constituted to conduct the inquiry on the alleged charges. The respondent could not disprove the above allegation of the petitioner by placing on record before this court. In this, his evidence, the resolution number 5, on whose behalf the then president of the SMC appeared and deposed as DW1, could not produce any document showing formation of any disciplinary committee as required under Rule 20 of the 2007 rules before imposing any measure penalty. Then, my lord, rule has been quoted that your lordship may speak and the complete page 196, paragraph 27. In the case in hand, on looking at the evidence, though the respondent has relied upon various allegations made at different levels and on an inquiry made by the inquiry officer from Joint Director of Secondary Education Assam, but no document has been placed on record or even pleaded that after the inquiry by the Joint Director of School Education Assam by the NSLE inquiry report as proved by the DW1, any disciplinary committee was ever formed. On looking at the annexer J as proved by the respondent, it appears that the then Inspector of Schools, while it's later, dated 25/3/2008, authorized the president of the SMC, Bapuji High School Hindi Medium, may act as per the provisions of the Assam Non-Government Education Institution Management and Regulation 2007, with further clarification that in the matter of removal, dismissal of service from a recognized school, the disciplinary committee shall furnish the charges drawn against the employee, and if the disciplinary committee decides to approve any measure or minor penalty upon the employee, same will be considered by the SMC for approval. In the case in hand, as stated earlier, there is no evidence that any disciplinary committee was ever formed, even after direction issued by the Inspector of Schools, Morigaon, by its later dated 26/3/2008. Well, that is also relying on that rules, which were yet to be enforced when the removal, the resolution number 5 was removed. Moreover, there is no evidence of framing of any charge, furnishing charge sheet to the petitioner, constitution of disciplinary committee as required.
But then how this letter of 25/3/2008 originate by the Inspector of Schools? Para 27, you had just read.
Yes.
If he was removed in 22/8/2007, what occasion this letter to come into existence? Para 27,
Yes,
196.
I thought your worship, my lord, but I don't have an answer to that because I don't have that later. The record that was happened time on us regarding the resolution passed by the managing committee and the PM group saying that the communications were not received by the respondent. So these communications, my lord, those reports I will.
No, because why I'm saying so is that there must be some event which has taken place after 25 on or after 25/3/2008.
There can be some communication from the school also.
No, so some event must have taken place. Otherwise, why would this be relevant to the adjudication of the tribunal? Because as per your list of dates, this removal is of 22/8/2007.
Yes.
So naturally, nothing should follow after that.
After that, my lord, the resolution has to be, my lord, sent to the inspector for approval.
No, it's only sending out for approval. But why this communication? I'm just trying to understand the scope of communication. Because the tribunal gives a finding that this letter of the inspector of schools was not followed. Therefore, it was set aside. That's where this query.
That and
Can you get that record, Mr. Khatanier? Page 196. In the middle, you will find there's a reference to Inspector of Schools letter dated 25/3/2008. Mr. Sheikh, you have that letter with you? No. This letter which I am referring in page 196, is it available with you? No.
before the tribunal.
Yes, that's what I'm asking him. That's why I'm asking him. Please show us that letter. Please pass it on.
All the schools inside it.
125.
Responsibility in respect to the WPC.
Okay.
So this is pursuant to a letter of the BSNL Act.
Okay.
Direction of the BSNL.
Okay.
Direction is dated 7 March.
The other members of the bar, if I am continuing with this, I would not have time for other matters. Because I'll be rising at 4 o'clock. No, we'll continue our matter for the other matters. No, I don't want the lawyers to be waiting. I may not be able to take up because I think Mr. Sheikh will also take some time to make his submissions. Other matters I may not be able to take up. I will be rising at 4 o'clock. Please continue.
So we were at page 196. Right?
Yes.
In paragraph 28, in the case in hand, as stated earlier, there is no evidence that any disciplinary committee was ever found even after the direction issued by the letter dated 26/2015. Moreover, there is no evidence of any charge, punishment charge. The resolution and constitution of the disciplinary committee is required under Rule 20. The headmaster of the school himself is delinquent. Holding of any inquiry by the disciplinary committee and the findings of the disciplinary committee before the disciplinary authority and then appealing to the FMC. The only document which respondent has placed in the meeting is dated 27/2007 of the SNC has adopted resolution number 3 for termination of Ramanuja from the state school and that in the SNC meeting the governor was personally present. Then paragraph 15. Thus, here is the finding. Without going into the details of the documents proved by both the sides and the allegations and counter allegations against each other, from the fact as discussed above,
it is proved beyond doubt that in this case, the SMC of Bapuji High School Hindi Medium has acted in haste by not following the prescribed rules as narrated here before. The SMC even did not follow the advice of the inspector of schools, even while Exhibit J and thus acted beyond law. The action of the removal of the petitioner by SMC by resolution number 3 that is so and so is absolutely illegal. The same even violates the principles of natural justice. As such, the action of the SMC by which the petitioner was terminated cannot be allowed to stand and accordingly says. I'd like to mention here that for the purpose of brevity of the judgment, I have avoided discussing the various evidence and other documents proved by the either side due to arrival of the decision on the prima facie failure of the respondent to show fairness in their action of removal of the petitioner from service. In consequence of my above finding, by setting aside the resolution number 3 by which the service of the petitioner Sri Ramanand Jha was terminated as illegal, the consequential action taken, that is approval of Avdesh Kumar Singh, the petitioner number 1, as headmaster also held to be illegal and liable to be set aside, which I accordingly do. Now, my lord, my submission before lordship is the tribunal has allowed the petition primarily on the ground of violation of the rules and not following the direction of the authorities in the education department to follow the rules. As I have already said, those rules were not relevant for determining this. And it was a venture school, and there was no guideline as such as to how the employees of a venture school has to be dealt with. Secondly, persona number 5 was never a headmaster of the school, whereas the petitioner number 1 was appointed as a headmaster of the school, and more importantly, his services have been provincialized by the authorities. So, provincialization order of a regular headmaster has been, my lord, set aside on the ground that rules were not followed and natural justice was not followed in removing headmaster in charge. If at all, my lord, after all these, leaving aside the delay of 7 years, if it is held that the managing committee of the school did not follow the principles of natural justice, then, my lord, he goes back to the school as an assistant teacher, because this substantive appointment, which we might call it a substantive appointment, was as an assistant teacher, not as a headmaster. Petitioner number 1 was appointed as a headmaster. His services were provincialized only because the tribunal finds that the rules were not followed and the principles of natural justice were not followed. Therefore, his appointment is restored. But it cannot be to my post, which is a provincial post. If at all, my lord, he goes back as an assistant. And there has to be reason, my lord, why this provincialization is that. As on the date, my lord, when the school was provincialized, undisputedly, my lord, I was the headmaster of the school. Therefore, there has to be reason, my lord, the provincialization of the headmaster, service of the headmaster, can it be set aside only on the ground that, my lord, the assistant teacher was removed without following the principles of natural justice. Admittedly, my lord, there were no such decisions. There was no proceeding for it. There was a meeting, general meeting, where, my lord, the persona number 5 was present. His wife was also there present, because, my lord, both of them had the allegation theologically find, my lord, in the resolution. And in their presence, my lord, the resolution was taken. And that is how, my lord, venture school functions. Therefore, the provincialization of the petition of petition number 1 service cannot be, my lord, set aside in this time. And more importantly, the son number 5 has already attained the age of superannuation. And his service was not provincialized as assistant teacher also, because from 2007, he was not there in the school. Therefore, in the provincialization order, his name does not get reflected. Therefore, even if your lordship holds that his termination was bad, then at this he may be entitled to some salary, but which salary? The government will not give the salary because his services were not provincialized. And the school cannot give because from 2007 he was not there. In 2007 he has got his salary. I agree, my lord, the procedure should not, maybe your lordship may come to a finding that my lord, frequency from nature is becoming violated. But my lord, that does not, my lord, the action is challenging, my lord. Briefly, my lord, these are my submissions, and I'll place the record, my lord. The court wanting to see the resolutions are written, my lord, I consider it. But I had slightly, my lord, two reservations which I would relevant. And also the young group, my lord, so there's no, it's not in because we have a company as the individual, and the letters were sent to the home address.
People will take it up when required. Yes, Mr. Sheikh.
Okay.
Which document? Page 42. No, you see, come to page 132. Who is Ramanand Jha? You are Ramanand Jha. Page 132. Second para. Petitioner was serving as assistant teacher of Bapuji High School, Hindi medium, Jagir Road since 10/9/1992, whereafter he was appointed as headmaster on 22/6/2001. So where is that appointment letter?
There has been appointment in the resolution, of course, smaller than this, that resolution now there I'll ask for it. But there has been appointment later.
I don't know because it's a order of the court. We'll call for the writ petition. It will be available there. Page 42. MC resolution number 1, appointed as headmaster. No, you see here what has happened is that this is a provisional approval.
I'm sorry, my lord, this resolution dated 26/2001. That was filed in a. The resolution is there in the on the file. The additional application. The IA, my lord, 3096.
Just a moment. What is the final order passed in WPC 6-3, 6274 of 2012? Is it available?
My lord, 2553 of 2007.
Hmm? 6274 of 2012. Has any final order been passed there? Because Mr. Chaudhary, Mr. Sheikh appears to be right. There is no document showing that, except for your affidavit filed somewhere, that is in the proceedings of 6274 of 2012. Nowhere else it appears that he was appointed as a assistant teacher and was ordered to hold the post of in charge headmaster.
My lord, two affidavits, those documents has been annexed, my lord. One affidavit filed on 21/9/2022, where my lord, the entire resolution has been, my lord, this resolution dated 22/6/2001. And produce the original, but it is there already on record, my. That is so, my lord, we were giving on temporary basis because the operation number one resigned from administration. Find on 21/9/2022. Also in the idea. 2096. 19.
Just a moment. Which page?
With the capability on 29, my lord, the translated portion is at page 6. The original photography at page 7. Running through will be my lord 207. Running through 207. And then
Yes, this is in charge headmaster. I'll continue some other day because I have to rise. 40. Yes. This is resignation as headmaster. Yes.
Yeah, it was of number 16/4/2001. To be Nandalam for that, but not, you know that, number 16/4/2001.
Yes. Okay, we'll take it up some other day because I have to rise. Mr. Sheikh, we'll take it up some other day because I have to rise. Okay. Well, MK Chaudhary, Senior Counsel, assisted by Mr. D. Bora, Counsel for the petitioners. His submissions are concluded, reserving right to reply. Next, Mr. N.J. Khatuniar, Learned Standing Counsel for the Secondary Education Department, and Mr. M.A. Sheikh, Learned Counsel for the respondent number 5 are present. This is a parted matter on. It's a date of hearing. Just exclude that day of special bench, division bench. Give any other day. Fourteen 11, yes. Okay, 15/11. Huh?
Yeah, I don't have any difficulty, but my hearing may be.
The 16th is again that there is a special bench. Well, that will be 16th then. Because in the first half, there will be the division bench, in the second half.